Well, hello everyone, and welcome to Uncivil Law, where as always, we learn through the misfortunes of others. I am your host, Uncivil Law, a licensed attorney in both Texas and Virginia and before the United States Supreme Court. And we are here today in the ongoing trial of Scot Peterson, a school resource officer in Parkland, Florida. The Parkland school shooting occurred February the 14th of 2018. The shooter himself has already been tried, convicted, and sentenced to life in prison. 14 students and 3 adults were killed. 17 others were injured. Scot Peterson was a fully licensed, badged police officer. His duty station was the school, as opposed to being a person who walks a beat, as opposed to being a person in a patrol car, as opposed to whatever else. His duty station was the school. It had been his duty station for 9 years. He is being accused in so many words of cowardice, failure to act, negligence, leading to the death of children and adults, and also one count of perjury for lying during an investigation when he was subject to the penalties of perjury. The campus in question is a very large campus, 45 acres, 3,000 students. And he appears, based on the evidence that's available, to have been the only police officer there while the shooting was occurring. Although the facts are slightly unclear if any other officer was there during any point of the shooting at all, it was only at the extreme tail end. So it seems that during the entirety of the shooting, for all practical purposes, he was alone. We don't have a lot of information yet as to what he did. So far during the trial, we've had emotionally heavy testimony. We've heard from a rotating band of students, teachers, and other police officers who responded to the scene, mostly for the information about varying degrees of the horror show, how they were affected, how they huddled in corners, how they heard the shots, how they were scared out of their life, and also the damages that they incurred. Some of them had been shot. We've seen some of the bullet wounds on their body because they were shown to the jury and also shown to us. So far, we've led with what I would describe as emotionally heavy testimony. Testimony that technically, in a legal the jury. Now, this isn't an invalid strategy by the government. To lead with emotion isn't a bad idea. You can prime the jury to care, right? You need the jury to be caring and engaging. And so it is not necessarily a bad or invalid strategy to start with some emotion. And also, it's not necessarily a bad idea to do things in segments. So the idea, maybe we'll do all the emotionally heavy stuff, and then we'll do this, and then we'll do this in segments so that they're all discrete. An interesting idea. I found the testimony so far to be a little repetitive to my taste. Also, I think perhaps it's a bit of a strategic mistake because you can run into the possibility of the emotion being so high that you get emotionally burned out. Now, that's probably less of a concern when it comes to the murder of children, especially 14 of them. So perhaps they are less concerned about that. And that's one of those things, obviously, that you have to feel out a little bit more in the courtroom and also part of the consideration. So I'm not really in a position to criticize the state. I'll just simply note some of the possible downfalls and that the state has taken a particular tactic. I will note that during their questioning, as well as the defense's cross-examination, have been very, very good technically on the tactics. So in terms of how they've executed the strategy, so far they've been essentially perfect. The defense lawyer has been a little bit aggressive at times. He has definitely tried to testify during cross-examination, gotten shut down a little bit by the judge, and also sometimes has asked questions so many times in so many different ways he's gotten slapped down for asked and answered. It's unclear to the degree to which this is all, again, a strategic consideration. So is he making a mistake or not? Unclear. Perhaps he's doing it deliberately. We've heard certainly lawyers tell about how juries say, well, you never told me that, even where they said something a lot of different times. I think Robert Barnes has said that in particular. I seem to recall him saying that. It's like, I said this 50 times and the jury said, I wish you had told me about it. And he's thinking to himself, I told you 50 times, but you never heard it. So maybe it's that. Maybe he's so concerned about the jury not hearing something that will tell them over and over again. Repetition being the mother of learning, as my high school history teacher used to love to say. And I remember it because he repeated it a lot. So maybe that's the idea. Maybe also he's doing it to deliberately try to invoke or entice the state to object because maybe he's hoping that the state objecting make it seems like they're trying to hide something. So perhaps that's all part of the strategy. So there are some questions onto that stuff. But if you put all that aside, where it's like a little bit more nebulous, and just look at his technical execution of the cross examination questions, they've been essentially perfect. So there's some strategic considerations that are perhaps a little bit questionable. But if you kind of ignore those elements and just go to the sort of root mechanics, meat and potatoes of the thing, he's been essentially perfect on cross, and the state has been essentially perfect on their direct. So they've both executed tactically very well. Some minor questions on strategy for both of them. Not necessarily an invalid strategy, just simply noting some of the potential downfalls of the chosen strategy. Which, to be fair, show me a strategy that doesn't have potential downfalls. Show me a perfect strategy, right? Doesn't really exist. So yeah. But so far, we've heard from this rotating band of students, faculty members, and police officers. We ended the trial on Tuesday with the medical examiner trying to testify about the autopsies they did, giving us some hope that perhaps we're moving on to other aspects of the trial. Also, the state keeps alluding to the defendant being cowering behind a car for 45 minutes, but we have not actually heard any testimony about that. So, would be nice if we brought in some testimony about the 45 minutes he spent cowering behind a car. There's been allusions to a tape. Would be nice if we could see it, because so far we don't actually have any evidence of that. We just have that being alluded to as a tease. And I'm ready to see the evidence, man. I'm ready to move on to other things, right? So, okay, we'll see how it goes in this continuing trial. Also, of course, there's ultimately the question of his legal liability under the relevant statutes. He's being charged as a caregiver, which I'm not sure that he is legally. So this whole thing is legally dubious. There was an illusion, again, an illusion in the opening to this being somehow a matter of contract. But again, we haven't heard any evidence of the contract. So maybe the duty arises from contract, which isn't an invalid idea. Duties can arise from contract, but we haven't heard any testimony about the contract yet. So we're a little bit iffy on the underlying duty. So we'll see how that all progresses.
That's pretty close to zipping all the way.
And a beautiful good morning to all of you. Just a kind reminder to please retweet the pinned comment. I even made the poll fun to encourage you to do that. So
What happened here? He jumped on that.
Oh yeah,
Oh, oh, this one tight?
yeah.
Oh, I'm sorry. I thought it was
It's kind of like a fail safe. I guess.
also, happy Flag Day, everyone,
okay. And then
for yesterday.
zoom out on this one.
God bless the United States and its flag.
Problem. Get the
Yeah,
whole thing.
so you
It's not a bad flag.
Yeah.
It's pretty good.
Just go over like that, and then zoom in.
Symbolic. 13 stripes for the 13 original colonies, 50 stars for the 50 states.
aside for evidence, and aside from that, whoever's talking, just be on that.
Here's a fun fact you might not know about the flag, and as long as we're doing some Flag Day stuff. When states 14 and 15 got added, they got their own stripe as well. So the US flag hasn't always had 13 stripes. States 14 and 15 got their own stripe. And then Congress kind of realized that that was kind of a bad idea because that would become crowded and went back to 13 stripes. The Star Spangled Banner, the actual song, Francis Scott Key wrote about the Star Spangled Banner, about the flag that was flying, was a 15 striped flag. This fun flag fact is brought to you by Uncivil Law.
It's like really back heavy, huh? Okay, let me see. This is there. It's trying. It's like. That's what I'm saying. The counterbalance on it is like really high.
I have also seen the actual Star Spangled Banner at the Smithsonian. I defied the things that says no photographs, and I took a photograph. Of course, I didn't use a flash because I'm not a monster,
Yeah, when you.
but I did take a photograph. So yes,
There's
it is a big ass flag. It's a really big flag.
no, unfortunately. Like,
So
you how many?
it's not surprising he was able to see it from the ship in the harbor because the flag is huge.
Oh, yeah. Okay, that makes sense. Okay, cool. All right, maybe I'll send you my Twitter. It might be easier for you.
I mean,
so it doesn't do that.
yeah,
I mean,
whatever you prefer.
I mean, it's for you. It'll make it easier for you. But if you think that you're fine with this, then you can hold on to it.
Yeah, because I'll be here. You know.
All right. Sounds good. I want to make it easy for you.
No, for sure. Appreciate it.
I can pull up a photograph if you give me a second.
Cool. Yep.
I'll find it. We'll share it together. Hold on. Let's see. Oh yeah. Oh. Nope. There it is. There it is. And you can see how big the flag was. Because, like, this is basically just the upper left corner of the flag. So you can imagine how big the flag was. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15 stripes. You can count them yourself. Big ass flag. Big boy flag. Big boy flag. I mean, you can tell how big this flag was. Big boy flag. Really big flag. So we've got the upper left corner of the thing. Kick ass. And there's signs saying don't take photos. So I snuck into a corner and took a photo with my iPhone. Or maybe it was my Pixel at the time. I think it actually was my Pixel. So I was able to get better dark light. I think I took this with a Pixel phone. So I took a couple photos, not bad. So, yeah. Put on the dark mode. That was more than 5 years ago. So I'm well clear on the statute of limitations on that one, so the feds can bite me. They're really concerned about the flash, obviously. I mean, that's really what they're concerned about is the flash, because the light will deteriorate the quality of the thing. All right, so they're concerned about people forgetting to take their flash off. So they just say no photographs, but whatever. I took a photograph. It was more than 5 years ago. Sorry for breaking your rules and all, but I have a cool photo, so eat me. You don't like the yellow fringe? Yeah, I don't personally think I like it either, to be honest. Yeah, I'm not sure I like it either. If I ever become a judge, I think we're going to go without the fringe on the flag. They say the trial is supposed to be 6 weeks. The state has indicated that they might rest as soon as the 20th. So we'll see.
Bless you.
Incidentally, for anyone who cares, I have unlisted the video I did of the live stream react to the redistricting case because the audio was so low. Because I forgot to readjust the audio that I had set for this trial because my audio was so low. And I was like, oh my God. So I've unlisted it, but it's okay. I've run it through an audio filter and it's back and better than ever before. And it will be reposted today at 5. So if you saw the video the first time but had trouble hearing it, the live stream is still available. If you like the live stream, it's just unlisted now. And the edited version with improved audio will be posted at 5 o'clock today. Because I had to reset the audio for this trial because of the audio being so low, and I forgot to reset it for the broadcast. So exciting. Fortunately, the audio was salvageable. It was just really, really quiet, so I was able to fix it in post, so I didn't lose the content. So that was nice. Sitting at the dock of the bay. The cameras in the courtroom are under the state law because this is a state court. Good morning, everyone. Good morning to everyone here. See who's here as we're waiting for the court to get started today. We have It's Trenton. Hello. Greg Palmer, Tony P. Rose is here. Glad to have Rose here as always. One of our fantastic mods. Starlight, Springstorm, Eric Larson, Debbie Blair, Stephanie Jones, Marie, Loxton, Tony P, Thomas, Eddie, Sandra Ramirez is here. Sandra Ramirez, also one of our fantastic moderators. Thank you for being here as always. Lisa, Denise, NJS is here. Kestrel is here. Catherine Fraser is here. Good morning, everyone. Mary's here. Good morning, Mary. Sandra Golden. Thank you. Good morning. Emma's here. Emma Hinn. May Wimple. Knight is here. Starlight is here. Fantastic. Lots of great people here. Tinkerboo is here. Gregory is here. The toaster oven should arrive this afternoon, probably by 4 o'clock. I'm sure it'll be here for dinner time. At the moment, I am having another happy day. Yes, I'm having a happy day. So I'm happy about all those things. Happiness is good. Rusty is here. Good morning, Rusty. Kim who? Pretty Mama? Mountain Prince? What's the first thing I'm going to cook in the toaster oven? Steak. Steak. Steak is the answer. B. Davis is here. Good morning. Godiva's here. Good morning from Olympic Peninsula, the rainforest of North America. Kick ass. I don't know where that is geographically. I'm going to Google that, so I will learn a thing this morning. Where is that? Washington State. Okay, I need further information. Large farmland of Western Washington contains Olympic National Park. Okay. All right. I need to know where. I understand. I need boundary lines. I need boundary lines with a picture of the entire state, please. You're showing me a picture of the portion of the state, but I need to see the entire state so I can understand the context better. Every picture is just a picture of the peninsula. I need the entire state so I can see it. Do I just need to pull up a state of Washington? Pull up a picture of the state of Washington. Every map is disappointing me. Every map is making me sad. Every single map is just a map of the peninsula without context of the entire state. All right, fine. I'll just pull up a map of the state of Washington. Fine. Okay. Well, that's a little bit helpful. All right. Okay, so I see. So it's like north of Aberdeen, and there's Olympia. Okay. And so it's that little thing there. And you're right across the pond from Victoria and Vancouver. That's cool. And right next to Seattle. That looks like a nice place to live. Might be a little cold, I would imagine, but looks like a nice place to live. Cool. Maine's cool. Maine is the state that's closest to Africa. Yeah, I think Goonies was Oregon. I liked it when the various people did all the context clues and figured out that Simpsons is probably based in Oregon, which makes sense because I think Matt Groening is from Oregon. So the Simpsons is Oregon. They never name the state in the show, but there are some clues based on various things that suggest it's Oregon. Only thing I know about Oregon is the Oregon Trail game. And, fording the river and trying to avoid dying of dysentery and shooting buffalo. To the 200 of you currently here, thank you and good morning. We're trying to get to 1,000 people watching. If we get to 1,000 people watching, I'm going to donate 100 memberships. So tell your friends. Fargo. I'm more of a warm climate kind of guy. So all else being equal, I'd also prefer like the southern states. So like I prefer, if I had my choice of places to live, it would be, Texas, Kentucky, Tennessee, Florida, South Carolina, Virginia, Georgia, maybe. That kind of thing.
I apologize for the delay in getting started this morning. A few things ran long in my normal division docket than I had anticipated. That's completely my fault. State, you ready to proceed with your presentation?
Yes, we are, Your Honor.
State, anything you need me to address before we get going?
No, Your Honor.
Defense, anything you need me to address before we get going?
No, thank you.
Alabama?
Please bring me through things.
I don't know. Just the states that come to mind when I think of states I'd like to live. Tennessee and Florida, along with Texas, don't have state income tax. So that goes a long way towards them being high up on the list. The fact they don't have state income tax. So, yeah. Kentucky has bourbon country. 95% of America's bourbon, which I guess is all bourbon in the world, 95% of the world's bourbon comes from Kentucky. So that's got it going for it. South Carolina is a state I grew up in and have fond memories. Virginia is a state I lived in for 15 years and have fond memories. So that's why I named those particular states. Georgia I named because it has Atlanta in it. So that's cool. Florida's got the Keys. Also got the Conch Republic. Shout out to the Floridians there. It's nice I can move wherever I want to. Yeah, it means more licensure. It might mean sitting for an exam again. But, there's lawyers everywhere, so that's nice. As long as I'm staying in the YouTube game, I don't even need licensure, although I kind of like it for that, just to, to have it. I think I'm going to start introducing myself on channels as Texas, Virginia, and U.S. Supreme Court lawyer. So I can get myself some additional cred. Hopefully that's not too much of flex.
Ladies and gentlemen, welcome
Yeah.
back. Come on in. Welcome back. Come on in. Once you're back at those same seats, you may be seated. All the parties may be seated. Ladies and gentlemen, those of you using
Uh-oh. It's a little early for this, isn't it? Okay, well. We have paused video. Exciting. Now we have a black video. Even more exciting. Now we have stripes. Further excitement. Oh, no, we're back. All right, great. And as always, I'll apologize in advance for the court audio because we do the best we can. It's already boosted at 600%. Volume is up all the way. We got subtitles on. And I might have to reduce my microphone back down. Note to self, if I do that, to try to remember to bring it back up so I don't have that problem again. That'd be great. Lord.
Sir, if I could have you come all the way up here to the witness stand once you reach it, but before you have a seat. If you
Oh, who is this? We're back to police officers? Really? Are we doing this again?
truth, whole truth, nothing but the truth. Please be seated. And sir, once you are seated, if I could just scoot that chair all the way up as far as it will go. Can you please state your full name and spell your full name?
Samuel Samaru. First name is Samuel. Last name is Samaro.
Mr. Kilburn, you may inquire.
Thank you, Your Honor. Can you please introduce yourself to the jury?
Good morning, jury. I'm Samuel Samaru. I'm Lieutenant Colonel for Broward County Sheriff's Office.
What does a lieutenant colonel mean? What is their responsibilities?
I'm the Deputy Chief, Second in Command of Patrol. So basically, every patrol contract city in Broward County, I'm the Second in Command that controls the contract cities, the courthouse, Port Everglades, airport, and such.
How long have you been a lieutenant colonel?
Approximately 3 months now, sir.
How long have you been with BSO in total?
I'm actually going to my 30th year at the Broward Sheriff's Office.
Did you say 30th? I'm sorry.
30th, yes.
So let's start back at the beginning. Let's go back 30 years ago when you were first hired by the Broward Sheriff's Office. In what capacity were you hired?
I was hired as a detention deputy.
And what is a detention deputy do?
I worked in a jail from 1992 to 1998, July of 1998.
And is there a rank affiliated with that job, or how does it work?
Deputy is the first step. Before that, I actually go on, you go sergeant, lieutenant, captain, major, lieutenant colonel, and colonel.
Okay. So going back to 30 years ago when you were a detention deputy, did you have training to become a detention deputy?
Yes, I did.
Approximately how many hours of training or how many days of training did you have?
Back then, it was probably like 12 weeks.
Okay. And what did that training encompass?
Basically, laws, procedures, pretty much just self-defense, firearms.
And did you have to go to like a detention deputy academy?
Yes, I did. Broward College.
Broward College. Okay. So after those 12 weeks, presumably you graduated.
Yes.
And you started working in the jails?
Yes, on the job, like OJT. We had no training officer per se back in those days, back in the early 90s. It's more structured now.
So you did not in the 90s have a direct supervisor who told you what to do the first, let's say, 6 weeks or 8 weeks you were in the jail?
It was, but not formalized, should I say.
It was informal?
Correct.
Okay. You worked at the jail for how long?
Approximately 5 years.
During those 5 years, how many or how often would you need to take refresher courses or training courses?
Annually, you go to annual in-service every year to stay current with current times with best practices.
Can you describe what in-service means?
In-service is a mandate. The Broward Sheriff's is very proactive. It's like continuing education. Every year there's something new, technology or case laws or operational or tactics. And in order to make your personnel be competent and equivalent to perform at their best, every single year you get more training.
How long was the in-service training?
It depends. Sometimes it's 3 consecutive days or 24 hours within an annual period.
Okay. Back then, when you were a detention deputy, was there any additional training besides the in-service training?
There were specialty classes standalone, which means that it was, you put in for it based upon seniority, you may be offered a standalone class. And standalone means basically it's an 8-hour, 16-hour block of instruction for a specific skill set, maybe firearms or defensive tactics or case law, something of that nature.
Did you partake in those back when you were a detention deputy?
I took part in several of them,
You did?
yes.
Okay. At any point during your tenure as a detention deputy, did you ever teach any of the training classes?
Yes, the latter part of my tenure in the jail from 1997 to 1998, I was assigned to the Correction Academy at the Police Academy. So I was a class advisor. So my job was basically to, almost like a drill instructor, but a little more than that, what I say. Basically on the academic side, talk about like interpersonal skills, jail operations, procedures.
So for 97 to 98, were you stationed at the academy or were you stationed still in the jail
I
center?
was stationed in the academy.
And where is the academy?
It's in Davie, Florida.
Is it at Broward College?
It's at Broward College.
Okay. After that, after 97-ish, where did you go next in your career at BSO?
July of 1998, I was assigned to the city of Tamarack as a patrol deputy.
Now, did you have to go back to the actual police academy for that, or how does it work when you become a detention deputy to a law enforcement, Department of Law Enforcement deputy?
There's 2 options. Option 1 is to reapply and you go to a full police academy. Option 2, which I took, was a cross-certification. You applied to go to the academy, but as you applied, you basically go to school at night. So while I was a class advisor at Broward College, I attended night school to fulfill the requirements of becoming a law enforcement officer, which is additional legal classes, driving, shooting, and a few other like patrol procedures.
How long was those cross designation option 2? How long did that take you to fulfill?
4 hours per night for probably approximately 4 months.
Okay. Every night, 5 nights a week?
Yes, sir.
Okay, so 20 hours a week for how many weeks?
Like 4 months.
Okay. Upon graduating from that, where were you assigned?
The city of Tamarack.
And in what capacity?
Road patrol.
And can you just explain what road patrol?
Basically call for service. We all live in cities or in Broward County. So my main function was to report for service to you, any call for service, from traffic accidents to a shooting to a robbery or burglary or petty theft. That's what my main responsibilities were.
And how long were you road patrol deputy in Tamarack?
I was a road patrol deputy for approximately 3 years.
And then after those 3 years, during those 3 years, did you take training?
Yes, I did.
Was that in-service training, the mandatory training?
Yes, mandatory in service.
Did you take standalone classes as well?
Yes.
Okay. At that point, did you teach any classes?
No, sir.
Okay. After the road patrol in Tamarack, where did you go next?
I went to from September
Water's good.
2001 to August of 2006.
What is the civil division?
Civil division is an offset of the Broward Sheriff's Office, such as the evictions, the domestic violence orders, writ of bodily attachment, which is basically a child support pickup order, levies and replevins, which are court orders to seize property or ask for money based upon outstanding debt.
During those, that was five years you did that?
Yes, sir.
Did you receive training in regards to that?
Yes, sir.
So that's like a specialty, the civil division, is it
Correct.
not?
Yes.
Do you receive specialized training for that specialized unit?
At that particular time, yes, we did.
Okay, and what did that training encompass?
We had quarterly training. So one quarter may basically be firearms. The second quarter might be building tactics, which is going to a building, searching it properly. Another quarter may be self-defense, like defensive tactics, we call it, it's basically self-defense. And the fourth quarter might be something, a scenario base. That time could be driving, could be anything else what they chose.
Okay, and are these trainings that you took every single year while you were in the civil division?
Correct.
Okay. Did you also do standalone trainings?
Yes.
Okay, approximately how many did you do standalone?
Um,
You can ballpark it for me.
maybe 2 or 3 a year based upon availability, and my assignment was very taxing, so I didn't have the opportunity to take many other
And by
classes.
taxing, did it take a lot of your time?
Yes.
Okay. Now, you just said the standalone are based upon availability. Can you just explain to the jury what you mean by that?
There are approximately 1,600 sworn deputies for Broward County Sheriff's Office, and the average class is billed for 30 participants. And we all work various shifts and assignments. You put in for it, and based upon the shift and availability, you get selected.
Okay. So it's not, okay. After the civil department, civil process, whatever, where did you go next?
I left the agency for like 9 months. I was undercover in Albany, Georgia, working with the feds. I came back to
Was this a task force that you were on? Or?
Yes.
Okay, so were you kind of loaned out by BSO to the
No, I actually left BSO.
Okay.
I didn't want to be a cop anymore for some reason. It was kind of crazy. And I went to Albany, Georgia, and I got hired as a police officer. And immediately I was undercover. I was undercover in the academy. I was a college student undercover, working gangs.
He was a college student
Yes,
undercover?
I adopted a few cases, and I worked with them.
So you actually went to an academy again?
What a narc.
Albany, Georgia.
Yes, Tifton, Georgia.
Tifton, Georgia. How many hours was that?
It was 10 weeks.
10 weeks. After that, after Albany, Georgia,
I came back to Broward Sheriff's Office in October of 2007.
and in what
I'm a deputy sheriff. I worked in unincorporated Broward, which is central Broward. Basically, the PSB is Broward and 27th Avenue, and I was a patrol deputy there.
So road patrol, what you started out with before this?
Correct.
Okay. How long did you do that for?
I was road patrol for probably 2 years because I was also a field training officer.
Let's slow down there. During those 2 years, did you receive additional training?
Yes.
Okay. Was this the standard in-service mandated training?
Yes. In-service mandate for everyone. It's ongoing. It's consistent.
So in-service training, every single law enforcement deputy,
Yes.
no matter if they're a lieutenant colonel or if they're a rookie road patrol, they must take the same classes?
Correct.
Okay. Now, during that time frame, those 2 years, did you take any standalone classes?
Yes, I did.
Ballpark it for me. How many classes would you say?
3 to 4 classes per year, based on the manpower. I worked in Central Broward, which is very fast-paced, one of the most violent areas to work, and scheduling.
Now, you also said you were an FTO. Can
Field
you
training
explain to the jury?
I was a field training officer. Based upon my experience in the academy and years of service, I was chosen or selected to train other new incoming deputies on procedures and how to handle calls to service.
What's the difference between the training at the academy and the training offered by field training officers?
The academy, to layman's terms, is basically building the house frame, the foundation and the exterior of the house. A field trained officer is the fine finishes, the furniture, the intricate parts of law enforcement, from investigative and putting things which you've learned in theory into practical use.
Can you explain to the juries, a deputy graduates from the academy, they are hired by Broward Sheriff's Office, they start working on the road. Is that when they're assigned a field training officer?
Yes,
So it's the freshest of the fresh, the rookies. So to
correct.
speak. And how long, for an individual deputy, that you were their field training officer, how long did that last, that you were a particular deputy's field training officer?
At that particular time, it was 12 weeks. We were assigned a trained deputy for 4 weeks. They stayed with us for phases. It's 3 phases. Each phase is 4 weeks. I'll take a deputy for 4 weeks and work on them on different procedures and policy of the Broward Sheriff's Office.
Now, are the phases broken up that you're supposed to highlight certain things that are necessary to be a law enforcement officer, or is it just to get different perspectives from 3 different field training officers over the course of 12 weeks?
It's mapped out, like phase 1 is basically observation, phase 2, they get more interactive, and phase 3, the deputy is supposed to be on their own. But working in Central Broward, it comes at you pretty fast. So your first day, you can be involved in a shooting, a foot chase, a robbery, a rape. It's not that structured in that particular area.
And if a rookie is on their first day, they're faced with a burglary, is it the field training officer that will help them, guide them through what to do? Kind of like learn with their feet to the fire, so to speak?
Right, they'll attach to the hip. You follow me, whatever I do, you do.
Field training officer, were you field training officer the full 2 years that you were there?
Yes,
Okay. So 12 weeks program, I'm not going to do the math, but you had quite a few new rookies that you were training.
correct.
Okay. Did you take training classes to become a training officer?
Yes.
Okay. How long, how does that work?
I believe It was
Yeah, Supreme Court opinions are
48
dropping. That's right. I had forgotten
training
about that.
based
Thank you
on
for reminding me.
Justice Standards and Training Commission, but it could have been 40, it could have been 80. I don't
They're
know.
dropping today and tomorrow. Let's see what's coming down the pipe today.
To become a field training officer.
Correct.
We might try to do a little bit of both. That'll be exciting.
No, those 2 years I was in Central Broward.
I'm sorry, Central Broward.
Okay, the Indian
I
Child
went to
Welfare Act case. That's
called the
pretty big.
Selective Enforcement Team. So basically, I dealt with street level crimes, narcotics, prostitution, robbery suspect, burglary suspects, and I did that for approximately almost 3 more years.
Were you a detective in this?
Sovereign immunity and bankruptcy,
Between a detective and a road patrol deputy.
abrogating tribal
Detectives have
sovereign
more
immunity.
specialized training,
Yes, that
also
makes sense.
Their job function or purview.
Let's see. Indian Child Welfare Act.
Their ability to solve crime or address certain issues, whether the district chief or the district captain.
So is it accurate to say road patrol kind of responds to 911, driving around the street if they see something, whereas the detectives have more of an investigative role?
And Smith versus United States.
Detective in the SET team, the selective enforcement team, did you have to have additional training for that?
You do. You take basically class like narcotics identification, some investigative classes, criminal investigation. And in my case, it was very unique because I came from Albany, Georgia. I was basically on-the-job training. I worked with the feds. I was undercover, which is kind of an odd person to put in that unit. I already had the experience of dealing with different levels of crimes.
But with that said, you still had to take the training?
Yes.
Okay. And at that point in time, while you were on the SET team, were you teaching any classes?
No, sir.
Okay. After the
Okay,
SET,
interesting.
where did you go to next?
I got promoted August of 2012.
To what rank?
Constitution permits a retrial of a defendant following a trial in an improper venue conducted before a jury drawn from the wrong district.
Patrol in Central Broward.
I was patrol
Mm.
sergeant from August 2012 to February of 2013.
Now, during that time frame, and it wasn't that long a time, did you have additional training as well?
They give you new sergeant orientation, basically how to be a supervisor, line supervision, understanding how the dynamics of setting up your day, scheduling your people, understanding the dynamics of leadership, and addressing issues that come on as calls for service.
Yeah, it looks like no double jeopardy. I know. That's what got my attention.
After that spot, where did you go next?
I was transferred to the training division,
And this was when were you transferred to?
February of 2013.
What rank were you February 2013 when you went to training?
Sergeant,
So you started off in training as a sergeant.
correct.
How does a deputy become a sergeant? What's the process?
First of all, it's years of service. There's a cutoff. It might be 3 years or 5 years, but you study, you take some books, you study different books, and you basically take a leadership perspective. As a field trained officer, they made me the officer in charge. So I was responsible basically for handling calls. The sergeant, like, hey, you know what? If you plan to be a sergeant, let's see how you perform as a sergeant. And you study, you may take a class called
Okay.
line supervision.
Interesting.
And pretty much that's it.
Is there an exam associated with that?
How many trials are going to be redone? Probably not very many, I would imagine,
Pass
but
the exam to become a sergeant.
You take a written exam
We'll
based
take a look
upon
at it.
policy, state statute, books on
you
leadership.
literally can't hear anything,
You take that
Kristen?
class,
Or you just
that
mean it's
class,
quiet?
you're ranked, the top 50 per se. After the top 50 is selected, you go to an assessment board, which in turn gives
I can't make the volume any louder. There's nothing I can do.
And they give you scenarios, critical incidents, employee problems, and just different issues. How would you proceed in your thought process of handling that particular problem?
If you pass that portion of it, you become a sergeant.
You're placed on a list for eligibility, and then you're selected as supervisor based upon the need of the agency.
Okay. Ultimately, you were placed on that list and you became a
That's
sergeant.
correct.
Okay. Sergeant in training, what was your responsibilities as a sergeant in training?
My responsibilities was basically to coordinate training for 1,600 people at the Broward County Sheriff's Office and Department of Law Enforcement. Being agents aside, we had phases. Like phase 1 was from...
Who is Rise of the Legion, Rose?
Phase 2 is right from March to August, and phase 3 is from probably September, December. And we pick a topic. It may be firearms for the first 4 months. Second topic may be driving. The third topic might be active killer or building tactics or self-defense, such as defensive tactics.
As a sergeant, you're coordinating this. Are you also coming
You're
up
good,
with
Russ. I was just teasing.
lesson plans for training as well?
As a sergeant, your responsibility is to look over the lesson plans, add content, review of it, and most importantly, make sure it's best practices or vetted. You just can't, for instance, as a sergeant, I look at reference materials. If we're going to build a lesson plan, it has to have content to it. If one of my deputy trainers was to develop a lesson plan and put as a reference source Wikipedia as automatic, I will strike through it. Wikipedia is not a better site. You can't use that. I want something that's been accredited or met by standards such as the Criminal Justice Standard Training Commission for the state of Florida or from another agency, something that's accredited that we could hold or hang our hat on to best practices.
So from February to 2013 until what?
This and
date did you start
Wikipedia.
in training?
Mean.
February of 2018, from February 2013 to February of 2018.
Okay, so in those 5 years, how many lesson plans would you say you reviewed?
Conservatively, let's do 6 to 8 per year times 5 years.
So somewhere between 35 to 40?
Correct.
Okay. Now, of those lesson plans, reviewing, you have to vet whether or not it's a meaningful and purposeful training, correct?
Yes.
Were there situations during those 5 years where you had the people that gave input into the lesson plans change it?
Yes.
How often did that occur?
It's going to be that kind of day. All right, fine.
You could put because it may be a case law practice that comes out in January of 2023, but by March, a case law has been changed or some update that.
There, it's your what's being taught is the most up-to-date information.
Correct.
And the lesson plans that you review, that you approve, you actually have to sign off on, correct?
Yes, I have to review it and place my initials on it with a date
And why is that?
to verify that I actually looked at it.
Okay.
And the next level of the lieutenant that comes after me, they want to validate that I actually looked at this plan, went over his plan, made sure it was almost up to the final product, 95% completed or better.
Now, you basically just explained it, but can you, part of it, can you explain the approval process of a particular lesson? Does it start until upon completion where?
A lesson plan starts with a topic. The deputy picks a topic. They follow a structure. Plan together. I review it. During the review process, I may make changes, amendments. It gets approved. I sign off on the approval. The next step, it goes to the operational lieutenant, next rank up above me. He looks at it, review it. Next rank above, and the final say so the director. At that time, it was Major Schultz.
So after you review a Major Schultz, that's a review.
He's a final approval.
Final approval, okay. After February of 2018, where did you go?
I was promoted to the rank of lieutenant, and I was assigned to the city of Pompano Beach as a shift commander.
What's a shift commander?
I was responsible basically for 26 deputies and 4 sergeants on midnights patrolling the city of Pompano, the east side and the west side.
I want to go back to one question I forgot to ask. February 2013 to February 2018, while you were in the sergeant in training, did you also have to take training classes?
Yes.
Okay, can you just explain that?
I took a lot of classes. For instance, one of the most important classes I believe I took was in force science, understanding the dynamics of shooting and officers' response to stimuli.
All right, so he's here as a subject matter expert on how officers respond to stress.
The majority of
All right,
law enforcement encounters
fine.
is use of force, and how can we handle situation, the best practices for handling situations or critical incidents, per se.
Can you just explain what use of force is?
Use of force, it's more like a matrix, where I say, or steps. We used to have steps. Different response, a subject or a suspect, they provide some type of resistance. A law enforcement officer has to respond to that resistance at a certain level, and it has to be reasonable, necessary and reasonable. For instance, if a person was shoplifting and a deputy went in there and the person stole something, ran outside, they're fleeing, you tackle them. You might have to tackle them. If the person gives resistance, like throwing a punch at the officer could respond with a punch or a taser or baton or pepper spray. If the person is sat right here, they have no level of resistance.
So we're going to certify him as an expert on the subject of, this is all preliminary to certify him as an expert
It's
on the
for
subjects
adapting to
of
the Broward County Sheriff's policy.
essentially stress response for officers. That's why he's here.
Is this something you also taught during
Yes.
your tenure?
Yes, I did.
For how long?
For all 5 years in the training division.
Okay.
Oh, thank you,
not only
Gregory. That's
wrote
nice.
Lessons plans, but you actually trained officers yourself.
Yes.
Okay. What classes did you train in? Did you teach?
I basically taught the use of force classes, 64 classes. That's what it took to get the whole entire agency through use of force every single year.
64 individual
Classes
Okay.
with 30 to 32 participants.
Did you take classes outside of Broward Sheriff's Office for your role as the sergeant in training?
Yes. Like I mentioned before, the force science class. There's other supervisory classes I took. You take, for instance, also managing critical incidents.
And these are external from the academy over in Davie. These could be throughout the state or throughout the
It could be vendors, yes. You have subject matter experts from different agencies or maybe from the college. You just take the classes and you get, the content and you formulate it into a lesson plan to be taught at the Broward County Sheriff's Office.
Now, we're going back to Pompano in 2018, shift commander. How long were you there?
I was in Parkland for 1 year.
1 year. During that 1 year, did you continue to take classes?
Yes, I did.
Did you continue to teach classes?
No.
Okay. As a shift commander, how does that differ from field training officer in terms of hands-on teaching the rookies or the new people what to do?
It's not formalized training, it's more structured oversight. You're a mentor, a leader to the sergeants. There's deputy level, then there's sergeants. And your job is to facilitate resources and guidance in handling different situations from a supervisory perspective.
After that 1 year in Pompano, where'd you go?
I was promoted to the rank of captain in 2019, March of 2019, to train division.
So you were the captain in training in 2019.
Correct.
How long did you stay as the captain in training?
March 2019 to March 2021.
Okay, so for 2 years you were the captain. Could you explain to the jury what's the difference between, your new responsibilities as a captain? What did those entail in the training unit?
My responsibility was oversight of the train division. In layman's terms, I was the assistant director of the train division. And again, if we dial back to when I said in the approval process, I was basically the second signature for final approval of lesson plans, topics being picked, training for the agency as a whole. My purview expanded. I was no longer responsible for the Department of Law Enforcement. I was also responsible for the Department of Detention and civilian training. And any piece of paper, we have a form called TG7. It's a training request form. Every piece of paper that any person that wanted training for the agency, I was responsible for approval, denial on it for all 5,600 employees if they came through that particular office.
You just explained law enforcement, detention deputies, and civilians.
Correct.
What would the civilians entail?
They will take career advancement or proficiency courses,
Say it again.
career advancement or proficiency courses.
What would their job titles typically be?
Administrative assistant, community service aide, civil processor.
So even the civilians receive training
Correct.
through Broward Sheriff's Office?
Yes.
Okay. You were captain there for 2 years. During those 2 years, how many lesson plans did you have to approve or review?
Now it's like 50 to 60 a year because it expanded. It's no longer law enforcement, but I also see the correction curriculum or lesson plans. And in addition to that, I see the curriculum for the civilians. And in addition to that, now I'm thinking about it, the Guardian program. I was responsible for the Guardian program, oversight of the Guardian program, how that's ran for the Broward Sheriff's Office, and the cadets, the police cadets, and correctional cadets at Broward College also.
So at this point in time, when you were training, let's just say as a sergeant, you had to train 1,600 officers, deputies. Now as your role as the captain, can you estimate how many people you were basically in charge of training?
On the sworn side, 1,600 law enforcement, 1,000 Department of Detention, and probably civilians a little different because we're structured the agency. It may be 100, maybe 800, depending what requests for training that particular year.
Understood. Okay. During the time as your captain of the training unit from 2019 to 2021, were there situations where you, let's just use the word kicked back training, that it needed to be more structured or it needed something else added to a particular lesson plan?
Yes,
How often would you say that happened?
honestly, monthly,
Okay.
because I believe, and excuse my words, the devil's in the details. If you can't explain it to me, if it's not quantifiable, and the reason I say quantifiable, training has to be quantifiable and measurable. And what do I mean by that exactly in layman terms?
Is he here as a subject matter expert, or is he here to talk about the specific training
I want it measurable.
that
Like,
they
we actually
undergo on
taught
the issue?
This particular curriculum, we observe you do it.
Because they haven't actually certified him as an expert
Correct.
here. So is he here as an expert
So
witness or as a
I
fact
dug down to the
witness?
details, and the reason behind that is for liability.
I'm not quite sure yet. He maybe he's here as a fact witness to talk about how they're trained on the issue.
Training until 2021. Where was your next unit?
I was promoted to major of the training unit from
What's
20,
the, what's, I'm sorry, when?
20 March of 2021 to March of 2023.
So for those 2 years.
I thought they were going to certify him as an expert because they've gone through a lot of background, and normally you don't have to go through that much background just as a
Training
fact
division,
witness.
Of course, building security, the public
But
safety.
maybe I'm wrong.
At, Broward and 27th Avenue, and the reserve unit, reserve deputy unit.
In regards to the training aspect of it, as the major, you're the boss over the training.
Final say so.
You're the final say, you're the final.
Judge
say
said
on those
Tuesday there are no expert witnesses in this case.
On the lesson plans.
I'm sorry.
Did he really?
Were there situations during those 2 years as the major that you saw lesson plans that you thought needed to be more in depth or something along
Yes,
those
I
lines?
have.
How often would you say that happened as a major?
It was rare now because the captain basically was handling my particular position, my previous position.
I'm going to ask you a general question here, ballpark. But during the course of your career, from the time that you were a detention deputy in the academy to the time, actually, before I ask that, one more question. After 2023, what was it, March of 2023? Where did you get promoted to?
My current position right now is Lieutenant Colonel, Patrol Services.
Okay, so you're in charge of all of the patrol services?
Yes, sir.
And as a lieutenant colonel, are you still partaking in training?
I do. I teach new sergeant orientation, new lieutenant's orientation. So basic leadership. What's expected of you as a leader, as a supervisor?
So now here's the ballpark question. During your career, from the very beginning to up until, let's say today, how many hours would you ballpark that you took training? Not the teacher, but took training. How many hours?
That's a tough one. Per se, let's say, for instance, of a minimum 40 hours per year times
Say it again.
40 hours per year times, let's say 30 years.
Okay. Plus the standalone classes.
Correct.
Okay. Plus the time in Albany, Georgia.
Correct.
Plus the academy to become a detention deputy.
And cross-serve, yes.
And cross certification. Okay. In terms of classes that you've taught, instead of hours, let's put it this way. During the course of your entire career, how many classes have you taught? Let's start with by topic. How many classes would you estimate you've taught?
Use of force, probably 350 to 400 classes. Active killer, probably, I was there all the time, 60 times, 5 years.
So 300 times
yes.
active killer.
Yeah, so 300 is like the going number from sergeant. That's the bulk of my teaching.
Okay.
As a lieutenant, captain, or major, it probably dwindled down to 3 or 4 classes per year.
Okay. In terms of reviewing or approving lesson plans, ballpark it, the entire time that you were in a supervisor role in the training unit, how many lesson plans did you review and or approve?
Conservatively, probably 200, 250, depending on the topic. Because another component of a lesson plan, after 2 years, you need to review it. It might become stale. After 4 years, it's archived.
Your Honor, may we just broach sidebar very briefly? Sure.
Archived? Okay, well, we're pointing up the ceiling, I guess, to avoid stuff where we're doing a sidebar or whatever it is we're doing now. So yeah, I'm not 100% sure why this guy is here. Is he here to testify as to the training and practices of the police department in which the defendant was trained? So is he here as basically a fact witness of here's the training that we do? Or is he here as an expert witness to testify as to how people respond to stress? So I'm still not sure what his role is. We went through a lot of background. So it sounded like we were teeing him up to be an expert witness, but I'm still not sure which way this is going. Maybe it's a little bit of both, although it's a little bit unusual for a person to be both a fact and an expert witness.
What's already been entered into evidence as states 13, and Your Honor, we can show this. No. Well, no. Oh, this, the other one's. There we go. Thank you, Judge. Lieutenant Colonel, I know you can see this on your screen.
Yes.
A bit better. Do you recognize this?
That's called a TCR. I'm sorry, that's a historical training of a deputy.
Okay, does
I didn't hear that.
Historical training of a deputy.
And Your Honor, if it's working, can I please put on the annotated?
Oh, that's showing training history. Oh my God, law and crime. I swear sometimes. So this is a listing of all the classes the defendant sat in or took. Is that what this is?
I can just do it by.
Why don't we do the same thing? Now we're getting that.
It's fine, Your Honor.
We take that off.
Lieutenant Colonel, I'm gonna just point, you recognize this? though?
Yes.
Okay, does every deputy have something similar that shows all of the training that they've taken?
Yes.
Okay. Zooming,
Okay, so I think he's here as a fact witness. He's here to testify as to the training the defendant took, and because he does the trainings, he knows what they are.
who this training?
Fine.
Yes.
Who is it for?
Scott Peterson.
Okay. Now, looking at the second page, all the way at the bottom, do you see the date that it starts?
Yes.
Can you read that out, please?
3/29/1999.
Okay. Is there a reason why these documents only show training starting in 99 and not predating that?
It's based upon a system called PeopleSoft. The Broward Sheriff's Office from the PeopleSoft in 1999, prior to whatever record-keeping device they had or
So-
platform they had.
So in 99, they started implementing a computerized system to document.
PeopleSoft,
training.
correct.
Got it. Okay. Now, I'm gonna start on the earlier date. And if I could draw your attention to 109. Do you see that?
Yes.
Okay. And what is that? What's class? Let's just numbered 109. What was that in?
Tactical pistol.
What does tactical pistol mean?
Tactical pistol is a course where it's developments of fundamentals of handgun shooting, using a handgun. Stance, breathing, grip, trigger control, focusing on a sight or a target, understanding the dynamic of shooting, such as your breathing. Sometimes when you shoot, you get locked in, or I would say over-focus, like tunnel vision. So you control your breathing. It's called tactical breathing. You breathe and you scan to tune out tunnel vision or just getting too fixated on the target.
Is this a class that is typically taken by deputies?
Yes,
Now, is that a mandatory in-service training?
that particular course is a standalone course,
Okay,
voluntary.
volunteer. Okay. Now looking at 97. Do you see 97?
Yes,
And what class is that in?
tactical pistol.
Is that the same what you were just testified to?
Yes, or it might be updated. Same concept, but the curriculum might be updated with different drills or tactics.
Going back to 109, and I apologize, do you see the date in which this class was taken?
I can't.
Oh, I'm sorry. Can you see that?
Yes,
What date is that?
12/12/2003.
Then going to 97, just gonna let it put it on one page, going back to 97.
Okay, so this is potentially pretty interesting stuff right now,
9/15/2006.
showing about his training and how he's trained to deal with particular situations.
Now looking at
Okay, this could get interesting.
94.
Active shooter.
And when was that taken?
4/4/2007.
This is the active shooter training that you ultimately were responsible for teaching.
Correct.
300 times, give or take?
60 classes.
60 classes, I apologize. Okay. Now looking at 85, do you see that?
Yes.
Great officer training, what is that?
Great. It's a program for teaching students for gangs. It's specifically for school resource officers for their particular job responsibilities. It's not something a regular patrol officer would take.
So it's job specific for school resource
Correct.
officers. Now looking at 82. Do you see that?
Yes.
Okay. Do you see what it is?
Yes.
What does that say?
Florida Association of School Resource Officers Training Conference.
And that is what date?
7/20/2008.
That particular training, is that conducted by BSO?
No.
Okay, so that's a standalone.
External.
External, another part of the state or another part of the country?
Yes.
Is that a class typically taken by school resource officers?
Correct.
Is it exclusively for school resource officers?
Yes.
Looking at the next one, 81. What is that?
Firearms qualification.
And what date was that taken?
8/27/2006.
What is that class?
It's not a class, it's a qualification course. It's mandated by the Criminal Justice Standard Training Commission, state of Florida, FDLE. So every law enforcement officer in the state of Florida is mandated to take this course. And it's basically to show that you're proficient using a firearm. It's a 40-round course. You have 3 attempts to get to pass. If you don't pass, we remediate you.
What does that mean, remediate?
We give you additional training to make you get to the level of proficiency to pass this course.
Now that's a course every officer has to take.
Must.
Must.
Every rank.
Now we're looking at 76, once again. Do you see it?
Yes.
What does that say?
Firearm qualification.
And which date?
I'm seeing half, 10/12/2009.
Oh, sorry. Okay, same thing, firearms qualification.
Yes, standard.
Standard. Now looking at the other page, page 1 of 2. Do you see 67?
It's blurry. Can't see it.
Oh, it's blurry. Oh, let me see what I can do. As good as we're going to get, I think. Do you see 67?
Yes.
Okay. Can you read that?
Florida Association of School Resource Officers Training Conference, 7/25/2010 to 7/30/2010.
That's the same class that you were just described. That's not at
It's job specific.
job specific to the school resource officers.
Correct.
65. Scot Peterson, just to streamline this, I'll read it. Tactical pistol taken on 5/9 of 2010. Is that the same tactical pistol that you described before?
Yes.
That you earlier took? Looking now at 56. Scot Peterson, the Florida Association of School Resource Officers Training Conference, 7/17/11. Same as before, the same conference. not
Same
all-
conference, yes.
Looking now at 47. Scot Peterson, which one's that?
Active shooter,
What date was this taken?
August 16, 2012.
2012. Now looking at the next one. 45. Do you see it?
Yes,
Okay. Scot Peterson, DLE in-service phase 1.
right.
Is that a class that every deputy must take?
It's mandatory in service, phase 1,
Okay. And do you see what date it was taken?
4/9/2013.
Okay. Now, I'm showing you what's also part of Composite 13 for the state. Do you have to zoom out on this? Can you see that?
Yes,
Okay. Do you see DLE in-service phase 1,
Correct,
2013 active shooter incident analysis.
correct.
So is this the lesson plan for that particular class?
Yes.
Okay. Now, looking at the third page. Is that you?
Yes.
Okay. What are these numbers after it?
That's the lieutenant signing on my behalf.
Okay. So as you explained before, this process of submitted by, reviewed by an ICJS director, those are the people that have to actually sign off
Right.
on this lesson plan.
Correct.
So that means you signed off on this lesson plan.
It mean I sent it up and my lieutenant initial, JM 9407. That's
Okay. Now looking at this particular lesson plan. Part 2. Well, let me ask you a question.
Thank you for the gift memberships. Appreciate them as always.
yes.
Thank you for being such a strong supporter of the channel.
To the actual trainers themselves.
Thank you for everyone who hits that beautiful, beautiful join button. Just 99 cents to become a member of the channel. And every one of you who does so, it is very, very appreciated. Thank you.
That took this DLE 1 2013 active shooter training.
Yes, the trainer facilitated the training, and then we follow up with a training completion form report.
Okay. Now, it says directives on this right side. Do you see that?
Yes.
Slide 1, slide 2, slide 3. Is this like a kind of like a PowerPoint
Correct.
presentation?
Yes.
Slow down, please.
Certainly. In terms of the actual lessons, does it work that there's a classroom portion of it and then a real world?
A practical.
Practical. Did that occur in this case?
In this particular course, it's an overview, it's an analysis. It was probably at the range, because Zach Scott used to work for me. So it's an analysis, an overview of what occurs when an active killer.
So it's more of a classroom type sense.
Informational.
Got it. Looking at slide 4, do you see what it says there?
Participants,
Well, just the whole line right there.
yes.
What does it say?
Inform participants that all 3 cases, suspects either kill themselves or surrender when they perceive law enforcement contact was imminent.
Is that something taught, that during an active shooter, you want law enforcement to be present as immediate as possible?
Yes.
Why is that?
Well, active killers are focused on soft targets, which means a school, a church, an airport, a mosque. And the reason why is most attendees are not carrying weapons or law enforcement or trained to defend themselves. That's the perception.
Interesting. Active shooters pick soft targets. Whoa, what a thought.
When they're focused on these targets, if a law enforcement just enters a room, the presence of a uniform disrupts something called the OODA loop, which is a military term that we use for firefighter, the plane
Can you please
fighters.
spell that for the court reporter?
OODA loop?
Yes.
It's OODA and loop. It's an abbreviation. OODA loop.
Okay, can you please explain what OODA loop is to the jury?
So the first O is observation. Like, for instance, you guys are observing the monitor, okay? The second thing you do is called orientation. You're looking at the monitor and you're reading these lines as the SAO is bringing your attention to it. The D is direct, like you're gonna direct something, you're gonna take an action. So your focus now is on the screen, reading line by line. And the last part is A, for action. You're processing the information as he's saying it. He's telling you, he's giving you a number, you're processing, you're looking at it, okay, yes, I'm looking at the screen. He's going line by line. What am I reading to you? You're processing and you're acting upon it. You're giving a conscious thought to it. Well, in an active killer, they choose a soft target. They can't defend themselves. Kids, a church, a mall, wherever it may be. They're coming there armed to take as many lives.
Whoa. Active shooters pick soft targets where they're not going to face much resistance, where they'll be able to shoot a lot of people in a small amount of time. Maybe we should arm teachers then. Or maybe we should have, more security.
Now, looking at the bottom of the screen where it says slide 5, this portion here, you see where, please read that?
Explain that being able to prevent such incidents is near impossible. Our true mission lies in minimizing the damage a shooter can do.
Does that go part and parcel with what you were just saying, that speed, that timing matters, that to be is get there as quickly as possible. is
Yes,
important.
time's of the essence. The shorter time period, the less casualties, the less victims we have.
And then the line below that.
Identify the formula that more time a shooter has, the more victims he can kill. Our top priority is to stop the killing by any possible means.
Once again, is this in order, the time is of the essence
Yes,
to respond immediately?
yes.
This next one, slide, what's categorized as slide 6, can you please read that?
Maybe I should move to
Although
Dallas Fort
neutralizing
Worth instead of
suspects will end the
Houston.
threat,
I mean,
there are
being further
faster
away from Nate,
alternatives that
but
prevent
Dallas
the
Fort
suspect
Worth
from
does seem like it might be my
victims, such
speed,
as
especially
forcing
Fort
them to
Worth.
barricade himself or flee
Those are my
area.
people, right?
These need to be
Get a little
primary response.
conservative cowboy in me. They'll teach me how to line dance in
To
Fort
engage
Worth,
an
right?
active shooter doesn't necessarily mean to
Maybe
kill
that's
him
where I
or
need to
neutralize the
move.
target. It's to disrupt him, make him force an outcome, flee, barricade, surrender. By you doing that as an officer, basically you're mitigating the loss of life.
Now going down to where I guess it says slide 8 and then video of Carolyn Judger 2013. What does the top line say there?
Explain the potential delay in someone failing to take charge during a critical incident.
And then the next line there,
Explain the importance of the SRD position in schools.
and is that for layout purposes because the school resource officers are familiar with the setting?
Yes,
And down here, location information, is that what that means?
yes.
4 hours between Houston and Fort Worth.
Last
Oof.
one under slide 12. Can you read that, please?
Yeah, discuss the crucial time delay of waiting for the perfect four-man team and the possibility of considering a team of 3, 2, or single officer response.
So single officer was a response.
Do a flight between Houston and Dallas.
Back when this lesson plan was created back in 2013.
It's a long car ride, though. The state is too big. Lol. Thank you, Bri, for the gift memberships. Really appreciate it. Thank you so much.
This sheet, which I'll have to zoom in on. Looking at 37. Scot Peterson, Florida Association of School Resource Officers Training Conference, 7/2014. That's the same conference that we discussed earlier?
Yes, sir.
Okay.
Your niece lived in Dallas and found they didn't take the Northerners very well. That's funny.
Patrol rifle refresher.
And when was that completed?
I can't see.
Oh, sorry.
7/30 of 2014.
What is a patrol rifle refresher?
Patrol rifle refresher is actually what it says, a refresher course. Deputies are issued a basic patrol rifle, the fundamentals of firing a long gun.
Yeah, this witness is providing some material. This witness is speaking to the defendant's
In-service
training.
refresher training, they have to
He's
show
a he appears a fact witness to speak
operating
about the
this
defendant's
platform,
training.
weapon platform.
So he's a trainer himself, so he knows what these courses are. So that's why we went through the background to speak to what these courses are
Is it that you've been issued?
and what training the defendant received.
Yes.
This is all very valuable information.
So it's safe to say that by, I'm sorry, I lost. That by 7/30 of 2014, Mr. Peterson was issued a long rifle.
Yes.
Now I'm going to go back to a lesson plan. Zoom out. Do you see this lesson plan there?
Yes.
What is that?
DLE in service 2015 combat lifesaver.
So DLE in service, once again, means.
You woke up singing the Moo Cow song?
Yes.
And
Moo cow in my stomach.
Combat
Moo
lifesaver
cow is good
a
for
fancy
me.
term for
Moo cow
PTSD,
in my stomach.
and the concept
Good for
came from
post-workout recovery.
how can we mitigate the loss of life by using tactics
I lift weights.
field,
I
such
eat
as
steak.
tourniquets
I'm
or chest seals.
I
So
pull
basically,
cables,
wounds
I eat
caused by
steak,
gunshot wound
I
trauma.
use machines,
And why is
I
that
eat
important
steak,
for,
steak, 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 steak.
resource officer?
This training is very important based upon the fact of the likelihood of a school resource officer, based upon the training times of active killer occurring in school, is to mitigate the loss of life.
And is this training to stop bleeding as soon as possible?
Yes, stop the bleeding.
Based upon training experience, in order to stop the bleeding, you have to go to the victim.
You have to administer aid to the victim.
Just one last thing on this. Do you see your name there?
Yes,
Reviewed by?
yes,
So that means you signed off on this.
Right.
DLE in service 2015 combat lifesaver.
yes.
Now going back to the sheet, which I'll have to zoom in on.
Moo Cow was very cheap for me. My guy did a buy one, get one on Moo Cow.
Number 30. Do you see that?
Yes.
Okay. Scot Peterson. Handgun.
It was $12.
It was a 4 block.
It was $12 a
Fundamentals,
pound, but basically effectively $6 a pound.
on shooting dynamics.
And the steak I had yesterday was a little bit more than a pound.
How long that
I had a pound of T-bone
Special
yesterday.
lesson plan,
It was fucking great. It was like $6.
I'm sorry.
Fantastic.
4 hours.
$7 steak.
7/14,
Fucking
2015.
pound of steak in my stomach. Num 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 num.
Going to 28. Do you see that?
Yes,
Scot Peterson. Patrol rifle refresher. 10, 5, and 15. Is that the same patrol rifle refresher course that you described to the jury?
yes,
Number 25. Do you see that?
yes.
Scot Peterson, rescue.
No, my local butcher had a sale. So even better.
19 of 16. What is rescue task force?
Rescue task force is was a new concept at that time. Traditionally, an active shooter or a mass shooting, law enforcement arrive on scene. Fire
And my
rescue
local
stages
butcher had a sale. Buy one, get one.
to be forward-thinking
on T-Bone.
Broward
I'm
Sheriff's
like,
Office partnership
yes,
with the Fire
please.
Rescue Department. Implement the practice of rescue task force. Basically, fire rescue is going to wear soft body armor or full body armor and be escorted with law enforcement into the warm zone of an active shooter, which a warm zone meaning that the threat has left, but there's casualties there, there's victims there that need to be treated and extricated from the building or the venue.
Now I want to show you, it's part of States 13. I'll have to zoom out. Is this the lesson plan for the rescue task force?
Yes,
Who's the course coordinator?
I am.
Now, I'm looking at page 3. You also reviewed it?
Yes,
What date is that?
8/10/16.
Okay. Now looking at page 4. You see where it says contact team?
Yes.
What, can you please read that?
This first one scene, 1 to 4 deputies, they will be actively engaged securing or searching for the suspect, hot zone.
So back when this class was given 2016, it was also thought of that one deputy may actively engage or search for the shooter.
Correct.
And rescue task force, in terms of the extraction team, what's the difference between the contact team and the extraction team?
The contact team is the first 1 to 4 deputies or officer on scene. Your job is basically to search and find the killer, disrupt their mindset, mitigate the loss of life. The extraction team is the second wave of law enforcement prior to fire rescue entering the facility, the building, the venue, to start implementing combat lifesaver, field medicine, fast, hasty field medicine to mitigate the loss of life and injury.
And does that kind of combine with the combat lifesaver training that we just mentioned?
Yes.
Okay. Now looking at the next page. Hot zone, warm zone, cold zone. Can you please just describe describe that? I know you briefly started to get into it, but if you could just explain that to the jury.
The hot zone is active. There's shots being fired. You're seeing the killer actually doing the worst, the carnage. The warm zone is a lull after. The suspect has left the area, but there's still casual there. There's still a threat, possible of a threat, a second person, possible. And the cold zone is where there's no threat at all.
So when you say possible warm zone, what exactly, I didn't know you, but can you just expand on that?
Possibility is, in law enforcement, we have the concept of +1. There may be one shooter, maybe two shooters. Therefore, in the warm zone, initially the extraction team will present itself, secure the area, and then the rescue task force will enter.
Does the +1, the fact that there might be another
Assailant, yes,
or another, and +1 also applies if they have one gun, they may have a second gun.
correct.
Does the +1 in regard to an active shooter mean that the first deputy on scene doesn't need to go in?
No, it doesn't mean that.
What does the +1 mean then?
It's a potential shooter, another shooter, and if you hear gunshots, you got to go towards it. It means people are being executed.
Now, that same day, looking at this, I'll have to zoom in again, I apologize. So the rescue task force that you just explained was conducted on,
419 to
and it took 4 hours. Do you see directly above that,
active shooter,
which is number 24?
yes,
Active shooter completed 4 hours on, is that the same day as the RTF?
yes.
Okay. Zoom out here. Now, what exactly are we looking at here?
It's called a TCR, a training completion report. It's a report of the attendees, who was there as instructors, what course was taught, how many hours it was, and it has an association to a lesson being taught that particular day.
Now, do you see right here where it says course coordinator?
Yes,
Who's that?
that's myself.
Okay. Location, stockade. What's the stockade?
The Stockade is an older jail on Commercial and Power Line, 5400 Northwest 9th Ave, City of Fort Lauderdale, that is no longer being used to house inmates, that we have temporarily converted into a training venue.
Is this indoors?
Yes.
And what, the stockade, what is this used to compare to? What kind of buildings in the real world?
Well, the way the Stockade is structured, it's called E&F building. It's open bay. So basically, it's the equivalent of a school cafeteria, but for inmates. There's metal tables, there's bunks. So we simulate when we do drills on one particular drill that it's a cafeteria and there's an active shooter occurring and an officer, maybe 1 or 4, responding to that stimuli and addressing the situation.
Do you actually remember this
Yes.
class?
Yes.
You just were explaining cafeteria situation. And we'll get into this scenario that was
Okay.
going in a minute, but you can visualize, you remember this.
Yes.
That's your name down there?
Yes.
Now, looking at, this is the lesson? Oh, I'm sorry, I gotta zoom out a little bit.
This is very, very valuable information in sort of the technical aspects.
Yes.
Goes to his ability to execute his duty, goes to his training for his duty,
Yes.
goes to his preparation for duty,
Now, looking at the lesson plan,
goes to psychology,
where it says this?
Yes.
What are the priorities of life?
goes to a lot of things.
Priorities of life.
The first priority is the hostage.
So this is pretty valuable information for the jury.
Second is
I
the
think.
bystanders, the police, the third is police or slash deputies, and the last is suspects.
What does that mean, though, priority?
Part of life.
And I do like
Objective
using this
is
kind of
to maybe
first
multiply
before
hostages or innocents.
the video, because it makes the video much
Second
more
is
understandable
bystanders, and then
if it
third is
exists,
us,
right?
and last is
So it's like, okay, here's all the things that the officer
rendering
should have done. We
aid. The
trained
suspects
him,
being
we
out, and I had
went
basically
through all
the
these
first
exercises together. He had lots of experience, lots of training. He's been doing training since 99, or if not before. On a lot of these scenarios, we train in indoor scenarios. We train in hard concrete services like a former jail.
Why was that added to this lesson?
Traditionally, one of the most known active killer shooting was in Columbine. And that changed the whole way law enforcement approached active shooter training. It was kids. Unfortunately, law enforcement waited for other deputies or officers to show up, and a lot of lives were lost. So it changed the whole concept of how we respond in law enforcement to any active shooter.
And Columbine happened on April 20th of 1999?
Get a date? I'm not sure 100% of the date, sir.
Okay. Did it happen in 99? Do you recall?
Yes.
Okay. And you're saying that what happened at Columbine changed the way law enforcement will respond to active shooters?
Correct.
In what way specifically?
You no longer wait for a team. You cannot. Every gunshot is a victim. And as you're hearing it, that's live intelligence. You have to do something. Make a decision. And your decision, just mere presence, is going to disrupt, like I said, that person, that shooter is so fixated on the soft targets. Your job as law enforcement, the mere presence, is to disrupt their mindset and change their game plan.
Does that mean to go towards the sound of gunshots?
Yes.
Does that mean you must know precisely where the gunshot is coming from?
No, it does not. You search, you go into hunting mode. Every shot you hear is intel. And as gunshots are being fired, there's certain things that happen. The smell, you'll see casings. You may see trails of blood. You may see people fleeing the area from a particular direction. Those are all things we play into our senses to respond to that stimuli, which we try to replicate when we did training in the stockade.
And how did you try to replicate that in stockade?
We set a scenario of active shooter in a classroom or a cafeteria, shooting people making threats. We shoot blanks, simulate blanks. The deputy participant shows up. They gather what's going on. They see the scenario unfolding, and they have to respond.
So you're actually shooting off rounds, blanks, but rounds inside of a building.
Yes.
Do you also have actors or other employees running out?
Right. So you have the victims, you have the active shooter, and you have bystanders, like other deputies running out, screaming for sensory overload to give you, like, basically simulate if that happened in real life, what's going to occur. People's going to be fleeing from the scene. People are going to be victims. The shooter may or may not be continuing shooting, but how to address that situation as it unfolds from you. And they're going to point, like you say, where they're going. They're probably going to point in the general direction. They might give verbal. They might give.
I think you can use ketchup on a steak if you like it.
Maybe trails of blood.
Particularly in the morning. I like steak. I like ketchup on my eggs too.
All the breadcrumbs leading to
But maybe I'm a
what
strange
can I do?
person.
Where is this intel coming from? And
You know, the steak is the way that you like it, right? Yesterday I was using some chunky blue cheese dressing as dipping sauce, and it was fucking fantastic. So I'm
to
just
replicate
saying.
it. So when that day comes, you respond. It's, for instance, static drills where you stand and shoot a target is of no use to us in law enforcement. Law enforcement has evolved into using scenario-based training, such as active shooters or in traffic stop interaction. This may happen. So it basically gets you, like, if this occurs, I know how to respond. The more repetition you have, the better you respond when faced with that stimuli.
Are TI simulators or FAT simulators also utilized in training?
Yes.
Can you explain to the jury what those are?
FATs are basically interactive projection, and an officer may see someone pull a gun or respond a certain way, and you have a firearm, taser, mostly a firearm, to respond to that stimuli. So you draw your firearm to shoot or don't shoot for judgmental shooting, and you engage the threat or you don't engage the threat. It can be used for de-escalation, or it could be used for addressing a threat. But that's one form. The best form is scenario-based because there's live interaction, and when we do live interaction, there's actually scripts. We brief the role player. This is what you can do exactly.
Just going back to the FATs, just to explain to the jury, can you just explain the layout of the room that this is done in?
It might be a classroom, a projection screen. There's like 2 X's on the ground where you stand. The camera tracks you.
Cross-examination on this guy will be
Deputy
interesting,
behind you, playing the scenario
I
out
think.
that's been pre-recorded. and
but I
you
like what the
respond
state is
to
doing
whatever
here
scenario you
and
get,
sort of
and
getting what they need out of this guy and sort of,
software.
yeah, we train in a whole bunch of scenarios. He's been doing training since 99, whole bunch of training, whole bunch of things. We do training and simulated training, and we do it in good jail, which is concrete services. You have a duty to go towards the shots.
It's a
Everyone's understood this since Columbine,
Shapes the gun.
except in Uvalde, apparently.
A light emits, and it registers the shot on the screen, basically.
So it's a simulator.
Correct.
Okay, but scenario-based is real people.
Real
It's not
people.
It's not a simulator. It's not a screen with actors and.
Correct. It's interaction.
Mr. Kilroy, I'm just gonna press pause real quick. Ladies and gentlemen, I'm gonna give you a quick restroom break. Same admonition as always. Please do not discuss the facts
Cool.
of the case.
Yeah.
Evidence, the witnesses, or the testimony until we reach the end of the trial. I'll tell you when that is. If you leave the notepads in your chairs and step in the back for me for one moment, I will be right back with you. Thank you.
Yeah. I like what we're doing now. I like this witness and I like what he's offering. We're getting some information for sure from this about the police officer's training, knowledge, experience, and it speaks to his duty and ability to execute that duty. So, I basically in summary, what this witness basically testified to so far is, I'm a trainer, I'm a lieutenant colonel, I'm fairly high up in the police forces. I'm involved in a lot of training. We have a lot of training on a lot of subjects, as one would anticipate. Here's our training record since at least 99 when we started keeping it electronically. Here's some of the trainings. Here's all the trainings he's done. They'll present all the trainings. And here's some of the trainings that are particularly on point with respect to tactical pistol training, for example. So how to use a pistol in a tactical environment. Well, yeah, we have trainings. We use trainings with simulations. We do it at a former jail, concrete surfaces, unknown shots. We train on things since Columbine about going towards the shot. How do you determine where it is? Well, you use the information that's available and head towards the shots and towards that. And this is all really nice information, right? And it really helps. I really like this very much. So if the next thing that follows this is the tape, then I'm going to give kudos, unless they're going to do like more training stuff. So if there's more people testified at his specific trainings or stuff. So if there's other witnesses along those lines, then fine. But the next thing that happens in this trial is the tape, then I'm going to be very happy with the state, because the state will have made the context for it available, and then they can refer back to the training as well. And maybe this witness will be the one to talk about the tape. Maybe that's part of his testimony too. So maybe we'll get it from this witness, right? We'll first talk about all the training that he did and certain things, and then we'll go the tape, and then we can say, okay, is this compatible with this training? Is it compatible with this training? Is it compatible with this training? Is it compatible with this training? No, right? So this witness might be the key witness for the state and sort of the duty. So I very much like what they're doing. So, okay. So I have some potential quibbles on the way this is done, but the state made a choice. They made a choice for a valid reason. I think maybe I would have considered breaking up the emotional testimony. I don't know if we have any more of that. Maybe they've already done that. Maybe there is more emotional testimony to come. But I would have strongly considered breaking up the emotional testimony and having some come in after the tape and ending with that. Unless you think the tape is your best piece of evidence and you just want to end that way. But, maybe ending with, I don't know. There's a lot of strategic considerations, and I'm sure they've thought it through. So I have some notes on the strategy, but my notes on the strategy are coming from the viewpoint of someone who's not deep entrenched in the case. So my points may be invalid. So I think the state is doing a perfectly fine job, and at least on the tactics are perfect. So given the strategy, the tactics are perfect. They're asking the witnesses exactly what they need. They're getting what they need. I could have done without the detectives, really. I'm not sure what value they offered and served. Do we really need to go quadrant by quadrant in all the bullet casings? But I guess it's more horror show, so fine. A little tedious for my taste, but okay. So fair enough for all those things. So if this is the guy that's going to bring in the tape, that would just be the coup de grace, right? Really, for the state. But that would imply that's their last witness, and we think that's not true. Because the state said it's not going to rest. It wasn't anticipating resting until like the 20th. So I would think that if we're going to bring in the tape now, that would be our last witness. But we will see how it develops. So I don't know what more the state has to give at this point. What more is there? Maybe they'll bring in the tape and maybe there's more witnesses who can testify about the tape from their personal experience as well. So maybe we'll see the tape 8 different times through the lens of various witnesses who might have been there on the ground, who can testify about portions of the tape they personally experienced. Maybe that's what we're doing. We'll see. But this witness is a very good witness for the state. It's like, yeah, he was trained. He's been trained since 99. He had 19 years of training, at least, including school shooting scenarios, including scenarios involving unknown direction, unknown where the sounds are unclear, including in concrete environments, including in. So if we can then bring all that in and then bring the tape in and be like, well, is that consistent with this training? Is that consistent with that training? So forth and so on. Could be really good. Excellent. Very good. Yeah, prove he's a caregiver is still an issue on that. Apparently the judge is letting that go. The jury, again, I'm not sure what basis they're arguing caregiver. There's again been an allusion to a contract we haven't heard. If we were going to bring in the contract, I would assume we're going to do it before we go to the tape because it's a little dry. So I don't imagine that we're going to hear about a contract because I would think it would have already come up. Because you don't do this, then do the tape, and then go back to a dry thing like contract. Right? That's something you kind of put in the middle. So I assume we're not going to argue contract at this point, but we'll see. You bought Blue Trees Jessing because I made you? Excellent. To the 250 of you who are currently here, by the way, thank you for being here. Just a kind reminder, please. If you could be so kind as to please retweet the pinned link. 20 of you have so far pinned the link or tweeted the link. If we get to 50 retweets, I will gift 20 memberships. So if 30 of you could please retweet the pinned link who haven't done so already, I'll donate 20 gift memberships for your retweetings. So please retweet the pinned link and maybe earn yourself a gift membership today. Also, of course, we have some Supreme Court decisions. At some point, I'm going to have to cover them. When? I don't know. There's stuff dealing with the Indian Child Welfare Act, which is pretty big. I'd like to theoretically eat during lunch, so I don't know if we can do it during lunch because I'd like to theoretically eat, unless I do it through lunch and then put myself off camera when they come back so I can eat after lunch. We'll see. Today's lunch will be more T-bone. And then I think for dinner, we're going to make the ribeye in the toaster oven, and I'm pretty excited about that. The retweets that you guys do really do help a lot, by the way. They really help the channel in terms of getting exposure for the channel and making sure people are aware of the channel. It makes a big difference. So for those of you who have the Twitters, you can click on the pinned comment, hit that retweet. Takes all of 30 seconds tops. You can throw in a little quote if you like. Help to gain some exposure for the channel. Let people know what's going on. All that is extensively appreciated. And of course, it doesn't cost anything, which is nice too. Thank you for doing the things, Eddie. It's appreciated. Horseradish? I do have horseradish too. It's true. Hmm. What I need is like those little ceramic bowls that they give you at restaurants for dipping sauces. That's what I need. I need some of those. Thank you for liking the TikToks when they come up. That's appreciated. Thank. Creamy horseradish or regular? Regular is what I usually use. I like regular horseradish. Raw horseradish. They're called ramekins. Ah. Yes, that's right. I had forgotten that, but you were correct. They are called ramekins. Thank you. I had forgotten that. Let me give myself some ramekins. Oh yeah. Need little 4-ounce ones. Or maybe less than that. I'll look into it, but thank you. No need to buy ramekins? Easy to find for 25 cents a piece. Okay, I'll take a look. Fair enough. I'll go take a look at my thrift store. Cool. Thank you. Do you want us tweeting from the treetops? Yes, I want you tweeting from the treetops, and everywhere else. That'd be great. Please do that. Did I mute the audio?
Address
Yes, I
before
did.
we resume your direct examination. Defense, anything you need me to address?
No, Your Honor.
Okay, please bring the jury back in.
Tweet from all the places. Yes, please. 26 of you have retweeted. Thank you very much. If we could get 24 more retweets, I'll donate some gift memberships. Maybe earn yourself a gift membership today.
Mr. Killen, do you want me to try to reset the annotator?
If you could.
Ian showed me one trick, so let me see.
All right. I also need a brief restroom break. I will be right back.
So he's not able to circle anything, just so I know?
It's just when I hit that same annotator button, that's when we're getting the flash on half the
Okay,
screen.
all right, so we're finger pointing, I'll finger point.
Jurors entering.
Ladies and gentlemen, welcome back. Come on in. Ladies and gentlemen, welcome back. Come on in. Once you're back at those same seats, you may be seated. All the parties may be seated. Ladies and gentlemen, those of you using the notepads, I'll give you a moment to get the notepads back out. All right, ladies and gentlemen, when we took our quick restroom break, we were in the middle of the direct examination of the witness. The witness remains on the witness stand under oath. We're going to resume at that point. Mr. Kilroy, when you are ready, you may proceed.
Thank you. Lieutenant Colonel, going to the next page of the active shooter 2016. I want to focus on this portion here, where it says there are 3 desired outcomes for an active shooter. Can you just please explain what this means?
First option is to force the suspect to surrender. Second is to force the subject into a barricaded situation, such as SWAT will handle the situation since they are both the tools and the tactics. And the third is to incapacitate the suspect by shooting him, stopping the threat, or the suspect shoots himself.
Do all 3 of these desired outcomes require action on the part of law enforcement?
Yes, it does.
Looking at the next page, focusing down here, can you please read this?
The majority of incidents were over in minutes. There is a need to get there fast.
Why?
Time is the essence. The longer you allow the shooter to stay active, the more lives will be lost. Therefore, responding as law enforcement, your mere presence will force one of the 3 outcomes.
Going forward a few pages.
Thank you for the gift of memberships, Tony.
This portion up here. What is a single?
We do appreciate everyone
Why
who
is
gifts memberships to the channel. They are extensively appreciated. Thank you very much.
Most active shooters, when it occurred, sometimes the first deputy on scene or officer on scene, you are the initial person to engage the threat. Your backup may be miles away or preoccupied with something else. So again, time's the essence. If you were to wait, as our predecessors did in Columbine, there's going to be a lot more lives being lost.
So in this portion here, if you could just please read that.
If you're in a scene or in the area and you hear gunshots, you should immediately assess what you have and prepare to respond. Remember, every time you hear a gunshot in an active shooter incident, you have to believe that's another victim being killed.
Now, do you see any language in this lesson plan, in that portion, or frankly any portion that says you must precisely know where the active shooter is?
There's no such thing, sir.
What do you mean there's no such thing?
You can never actually pinpoint. You go into intel and you're using all your sensors. If you sat there to get the perfect picture, the perfect time, it may 2 or 3 minutes may elapse. Now you get a lot more problems. You got a lot more victims sitting there dying, bleeding out or dying in front of you.
And does that kind of go in with what it says down here? If you could please read that for the hearing.
Use your senses to gain a better perspective of the event, move with speed, and be decisive.
Is that what you were just telling the jury about?
Yes.
Now, going forward a few pages. Up at this portion, practice scenarios. You see
Okay.
that?
Yes.
What is a practice scenario?
It's a walk through the scenario. We kind of brief the participants. This is what's going to happen. You give an overview. First of all, you give the PowerPoint. You give the lecture.
In the line of fire, I have not heard of that event, but send me an email at kurt@uncivillawllc.com. If you know a trick for free passes and cheap accommodation, I may very well come to the festival. That sounds fun.
You're going to walk in this course.
I'm in. I'll go to Memphis. That's not that far.
It's going to begin.
Yeah, send me an email with
I gave
details.
you the pre-knowledge of sitting down, walking in, and what to expect. Testimony from a witness, examining from the attorneys. I'm prepping you, but I'm not going to tell you exactly what's going to transpire throughout the whole entire court process.
And to kind of highlight what you were saying before, you utilize exercises during this training, correct?
Yes.
Exercise 2, what is that labeled?
That was basically a practice for one deputy, solo response.
What was the scenario? What was the exercise?
In the stockade, there is this huge building. There's an exterior door. I'm trying to set the stage. A trainer standing outside the door. Matter of fact, if I could turn, this door behind me leads into a hallway. A trainer is going to stand right in front of the door. You're going to hear gunshots. I'm going to say, you, get in there and do something. As you go in, it's going to be sensory overload. You're going to see casings on the floor. You may hear shots being fired. As you look, you may see victims on the ground, or we have mannequins, and you will see an active shooter either commencing the shooting, dropping the gun, or holding a gun. And you have to respond based upon the stimuli you see at that particular moment.
This scenario, this exercise, was either created by or approved by you.
Yes.
Now, in the stockade, it's an enclosed area. When the gunshots go off, is there like a reverberation?
Yes,
Is there like an echo?
huge echo.
Huge echo. So as part of this training to account for your words, huge echo. To
Yes.
Get used to that. Is that part of the sensory overload?
That's it's a stimuli. Basically, to mimic as best as we can a open area, an airport, a courthouse, a school, a hospital, that you're going to hear gunshots, it's going to be echoing, but you can't just use one of your senses. You just can't use hearing, sight, smell.
Now looking at the last pages here. Do you see the sheet?
Yes,
What is that?
it's a sign-in sheet.
Is that used in training?
Yes, for every course you sign in.
And you see whose name is under number 1?
Yes,
Who is it?
Scot Peterson.
Does the information from that sign-in sheet then input it onto the sheet?
Yes, the training completion form, the TCR you guys saw earlier with the instructors, the course, and the sign-in sheet goes into a folder with evaluations. It's then signed off by the sergeant, the lieutenant, the captain or major. Then it's given to one of our training specialists who inputs that information into the deputy's profile to provide record of the training being completed.
Now, going back to this sheet here, a little bit. Looking at 22, Scot Peterson, handgun class in service, completed 5/13 of 15. Is that the same class that you testified to earlier?
Handgun class, yes.
Now looking at number 11, Scot Peterson, School Resource Deputy, range refresher, completed 8/16 of 17.
I'll take your word on that. I can't see the dates.
Oh, sorry.
Okay. Yes,
You see it now?
yes.
Okay. What is that class?
A specific qualifications or handgun class for school resource officers.
Why is that important, just for school resource officers?
It was additional training and help them to manipulate based upon shooting drills specific to operating in their job capacity.
Is that, like, what would that entail, like, specifically, the training?
Obviously, the lesson plan.
Okay. So looking at the lesson plan. And the course objectives.
Okay.
Can you just read that for the jury?
First objective, accurately identify and articulate the 7 shooting fundamentals. Utilizing a live fire drill, deputies will demonstrate proficiency drawing their pistol from their holster without error. Utilizing a live fire drill, deputies will accurately shoot their pistol at a distance between 3 to 50 yards. Utilizing a live fire drill, deputies will correctly perform emergency reloads during live fire, exercise with the rifle. Utilizing a live fire drill, deputies will accurately shoot the rifle at 50 yards.
Why is this important specifically for a school resource officer?
This is important to transition. For example, a school resource officer shows up in a building, a school, and the active shooter, they engage in a gun battle. They may first have went to their handgun, shooting, or transition to a rifle, or vice versa. If you don't have a rifle, at least you understand the fundamentals of shooting with a handgun for precise shooting from 3 to 50 yards.
What do you mean by precise shooting?
Target acquisition, understanding the dynamics of gun. If you hold your firearm with a firm grip, and in the movies you see people close their eyes, in reality you're not going to close your eyes. Both eyes are going to be open when you shoot. You present your firearm, you look at the front sight, the rear sight of a firearm. A firearm has a rear sight which is two metal pieces and a front sight which is one metal piece. During stress, shooting, the drills we are facilitating here, you focus on the front sight by a firm grip. Where your front sight is, that's where the round is going. If your shots are going off target, that means you're not paying attention. Don't look at the suspect, look at your sights. That's where the round is gonna go.
Lastly, on this sheet. DC number 7,
Yes.
and what is that?
Patrol rifle refresher,
Completed on which date?
10/31/2017.
And that's the same rifle refresher that we discussed earlier.
Correct.
Now, I want to show you what's also in evidence as states 13. During the course of your employment as a Broward Sheriff's Office, do you get certificates in things, the classes you've taken, or different certifications in regards to your employment?
Yes.
I'll show you what's already in this 13. Do you see this?
Yes.
What is that?
A certificate of completion, basically, from Broward College. It's a seizures course, criminal justice standard training, FDLE course, a structured, mandated curriculum to be a school resource officer.
And do you see whose name is on it?
Scot Peterson.
Do you see how many hours were taken
Yes, 40 hours.
for a school resource officer?
Yes.
And what dates was that?
June 24th to June 28th, 1991.
I'm going to show you another one. When you attend classes, do you sometimes receive certificates of completion?
Correct.
Do you see this one?
Yes.
Florida Association of School Resource Officers, do you see who it's for?
Yes.
Do you see how many hours of training?
Yes.
Is it 24 hours of training?
24 hours.
And what date do you see?
22nd day of July, 2016.
I may have asked this, I apologize, but it's for Scot Peterson.
Yes.
Now, as in your current role, Lieutenant Colonel, that's pretty high up.
Yes.
How many levels are above?
1.
What is that?
Colonel.
Then above that is the?
Well, the sheriff is running for election, yes.
Okay. In your capacity of that, do you have to deal with contracts, things of that nature, paperwork associated with that?
You do. You see what's going on between the cities, the Broward County School Board.
Contract, you
vendors.
say? Are we bringing in a contract now?
I review what's
Are
going on.
you doing all the
with my
things? Are you
issues
just the
or
best
legal
witness
issues
ever?
to me to-
Are you the best witness ever? Are you doing all the things? Wow.
That the sheriff's office signed with, you said it yourself at the school board.
Correct.
Okay, now I'm not showing you what's already been entered into evidence as parts of states 13. I'll scroll out a little bit. Is this one of those types of contracts?
Yes.
Do you see the date?
Yes.
What date is that?
August 15, 2017.
And do you see the purpose?
Yes.
What is that?
School resource officer placed at the following schools in Parkland.
And down here. Can you read that line?
We're getting something that might speak to
Deputies
duty,
served as
guys.
SROs at 2 secondary schools,
Woo!
West Lake and Marjory, Stoneman, Douglas.
Now, in this contract, so I'm going to try to zoom in a little bit. Under 2.05, duties of an SRO. Under sub A, can you please read that?
The performance of law enforcement functions within the school setting.
What does that mean?
Everything you've been trained to do as a law enforcement applies to school. It doesn't change. Life, protection of life, preservation of life, investigating crime, stopping people getting assaulted.
Now looking at D, can you please read that?
For identification and prevention of juvenile delinquency, in parentheses, including substance abuse, through counseling and referral services.
Is that responsibility as dictated in the contract, is that something unique to school resource officers?
That is job specific to school resource officers.
Meaning job specific, a regular road patrol deputy?
Would not perform those functions because as a school resource officer, it's a specialized unit in the Broward Sheriff's Office. So you're basically, your responsibility has certain requirements or expectations.
And including the identification and prevention of delinquency through counseling and referral services?
Yes.
So your typical road patrol deputy in Pompano isn't under contractual obligations to seek counseling or referral services for
No, sir.
Can you please read C?
For enhancement of student knowledge of the law enforcement function and of the fundamental concept and structure of law.
What is that?
As a school resource officer, your job is to basically be like a liaison, help them understand the concept of law and the structure of law.
Is that job specific to a school resource officer?
Yes,
Using the same example of a road patrol deputy in Pompano.
that wouldn't be their primary job function, no, sir.
And I just skipped over one thing at the top I just want to go through. Can you see the dates of the agreement?
Yes,
What is that?
August 14, 2017, and conclude on June 7, 2018.
So while this happened in Marjory, Stoneman, Douglas,
You're obligated to the conditions of the contract specified.
now looking to the next page, D. Can you please read that for us?
Development of positive student concepts of the law enforcement community and promotion of positive interaction and enhanced relations between students and law enforcement officers.
Is this something job specific to a school resource officer?
Yes, the key word is students.
Once again, same example, Pompano Road Patrol,
That's not in your job purview.
just in the job purview of a school resource officer.
Correct.
And there's specific training, as you highlighted before, just for school resource officers.
It's a specialized unit, therefore you have the training specific to that job description or job position.
Now looking at E. Can you please read that?
The provision of assistance and support for crime victims, including victims of abuse identified in the school setting.
Is that job specific for an SRO?
Yes,
Is that because of the verbiage or the language school setting?
correct.
Looking at F, can you please read that?
The presentation of educational programs concerning crime prevention and the rights, obligations, and responsibility of students as citizens.
What is that?
I mentioned earlier, I don't know if I could recall, two programs, such as DARE and GREAT. DARE is more drug-related and GREAT is more gang-related. These were specific programs entrusted upon school resource officers to educate and deter those kind of behaviors with our students in Broward County.
Road Patrol Deputy in Pompano, are they obligated or responsible to do such programs?
No, sir.
Looking at G, can you please read that?
The provision of assistance to School Board of Broward County in protecting and securing the school plant and its occupants.
What does that mean?
Your primary function and duty in that particular line is the protection of the occupants of the school. So hypothetically, the school is your sole responsibility. Everything within that school compound boundaries is your job responsibility to protect and serve.
I want to talk about police vests. Are you wearing a vest today?
Yes, sir.
What kind of vest are you wearing?
Level 3 soft armor.
What does that mean, level 3?
It will stop a 9mm round, a 40, and a 45 caliber round.
Can you just explain to the jurors who don't know what's a 9, what's a
So,
40?
a handgun. I'm wearing a handgun. So basically, it will stop a handgun round, not a rifle round. And when I mean stop, it's gonna, if it struck me, it will do some damage. It will disperse the force, break some ribs, but hopefully it won't penetrate. This I'll be having some injuries, but it'll give me blunt trauma.
That's for handguns.
Correct.
How about for ammo?
You may.
Show the witness what's already in evidence as states 27. You see the shell casing there?
Yes.
Are you familiar with shell casings?
Yes.
Is something of that size shot from a handgun?
No, sir.
What's it shot from?
A rifle.
Would a shell casing for a bullet, the projectile that was originally in the shell casing, would that bulletproof vest stop that?
No, it will not.
Your Honor, may I ask that witness to please stand for a moment?
Sure.
I'm going to ask about your gun belt. What is on your gun belt?
From left to right, a radio, a magazine pouch with magazines containing bullets. In between the magazine is a belt keeper. To keep the outer belt in place is 4 of them. 2 in the front, 2 in the back. Pepper spray, and my sidearm.
You carry pepper spray, but do some officers carry asps?
Yes,
And what is an asp?
it's expandable baton,
Thank you for giving me
That's
permission to sit
collapsible.
down.
piece of metal. That
Good
expands.
job. Defense forgot to do that with his witness.
Going back
It
to
was very awkward.
the training. The external
Push the button.
civil
Okay.
resource officer courses
Yay.
weren't taught at Broward College, the FA SRO. Are those refresher courses? Is that the purpose of them?
It's used as proficiency enhancement or basic continuing education. In the field of law enforcement, wherever you are, whatever specialty you're in, you continuously need to go to classes to get updates, as you would say. Like a school teacher, a lawyer, a doctor, we all have to get continuing education.
Yeah.
Now, going back to all the training, are deputies trained on the radio, to use their radio, the police radio?
Yes.
How extensive is that training?
Well, from the onset, being
Thank you for the
CI,
email. I'll take a look at
former
it. Sounds
CI.
great.
Once you issue your radio, they explain to you how to change the channels, how to talk on radio. And upon graduation from the police academy on the field training process, it's now 14 weeks. You use the radio every single day to get familiarity in communicating and understanding how the radio functions. So it's ongoing.
The training is ongoing to use the radio.
Yes, it's practical. I can explain to you how to use a radio, but the best form is, as a rookie, when you first start, is to have you start using the radio from day one.
And is there certain verbiage or certain words that are taught to be used over dispatch?
Yes.
For instance,
I could give my location right now if I needed to.
how would you do that?
I would say 11 Sierra,
And that's your number?
that's my call sign.
That's your unique call sign to you?
Yes.
Okay.
I am 97, which means I'm at Central Courthouse.
And at this time, I'd like to play for the witness what's already in evidence is states 7. We have to take that.
TVs have to be off.
Correct, Your Honor.
Okay. Court Deputy Unit, we need the TVs off, please.
Now, when teaching the radio, do you use specific examples? Do you use cases that have already been, or incidents that have already been recorded over dispatch to teach the newer rookies or trainees the proper and improper way to utilize the radio?
Well, we actually evolved from that. We actually have you use your radio during scenarios to facilitate what you would say on the radio. And if you cannot use a code, because we speak in 10 codes, speak in plain language. I'm here, I'm at this location, this is what's going on. Let's speak, because sometimes during anxiety, you may use a code. If you don't, let's use plain language.
And if you could please go to 223:26.
Juliet 3, 17 Bravo 3, 17 Bravo 4.
Juliet 3, we have possible, could be fire because I think we got shots fired. Possible shots fired, 1200 building.
In terms of the training, shots fired, possible shots fired, when are deputies trained to utilize those types of words?
When shots of active intel, shots are being fired at that particular location.
Now, is there a difference between shots fired and if the verbiage used or the words used and if you're being shot at?
Yes,
What are you trained to say if you're being shot at?
I'm taking live fire. I'm being shot at.
And why is that important, the differentiation between the two?
Shots being fired, it's someone shooting at something or someone. I'm taking fire like I'm actually engaged in a gunfight with an assailant.
And the second part of that dispatch, the 1200 building, is that something you're trained to do? Give the location of the shooting?
You're giving a location of what you believe of active intel. There's shots being fired. There's actually live shots being fired, currently being fired as you're standing there.
And if you're currently being fired, you give the location of the shots. Is that what you're trained to do?
Yes.
Aaron, if you can please go to 224:14. radio to confirm where shots are coming from?
Yes,
Why?
because someone might be stepping on you basically, which I mean by stepping. Someone might key the radio up and it didn't get copied by the dispatcher, so you affirm it. And the second time you say it's like shots are being fired again. I've heard a barrage of shots being fired. I'm giving you an update, hey, shots are still being fired at that particular location.
Is the specific language used when you're on dispatch important?
Pretty much, yes.
Okay. Aaron, if you could please go to 22424.
Any descriptions? I'm coming up from Westlake Middle. We don't have any descriptions yet. We just hear shots, but there appears to be shots fired.
Are deputies trained to again say shots fired?
Yes.
Why is that?
There's shots being fired. There's active intel, something's going on, please step it up, which means response, I need help. Something's bad happening right now.
Now, going back to the question before, there's a difference between shots fired and taking shots?
Correct.
Aaron, if you could please, you can just play it from your action.
I'm over on the south side, over by the 700 building. Daniel, tell me shutting down east.
Did you hear when it's over by the 700 building?
It sounds like gunfire in the background.
Okay. And also over by the 700 building?
Correct.
Okay. What, in terms of training, are you taught to say where your location is? Or are you taught in this situation to say where the shots are coming from? What is the primary thing you're supposed to be saying?
You're giving information on where the shots are actually being given, occurring at that time. The last thing you give is your location, unless you're taking fire. If you're taking fire, you explain, I'm being shot at, I'm taking live fire.
That's a little thin.
If you're taking fire, let's say sniper fire, is that something to be said over the radio?
Yes, I would.
Why? Why is that important?
It gives your responding officers and deputies intel, like the shooters from the elevator shooting at you, actually shooting at you from an elevator position.
So utilizing the word, for instance, sniper would be, you'd be trained to do that.
Correct.
Please go to Aaron to 22556.
Yeah, I wouldn't hammer such a what seems like a fine point. Like I'm here versus there. It seems like a fine point. I don't know about that.
Make sure there's no pedestrian traffic anywhere on Holberg Road.
Did you hear where he said inside the 1200?
Can you play back again, please?
Sure. Can you play that again, please?
We go to Bravo channel for regular traffic.
Some sort of say they thought it was firecrackers, and we're not sure. On the football field. All right, 26. So we also heard it over by inside the 1200 building.
Did you hear that?
By or inside?
By inside
Of the 1200 building.
What do you do? What are you trained to do in that situation in terms of saying 1200 building?
As in what
Is that
aspect?
another confirmation?
Yes, there's shots being fired in the 1200 building.
Now, in terms of training over dispatch, when you're repeating shots fired, are you trained that means there are continuous shots being fired?
Every update means there's live fire occurring. There's not a lull. There's a lull in between, but there's still shots being fired. Every time I come on the radio, every time I key up, I'm saying shots being fired. I'm telling the dispatcher there's somebody still shooting at this particular location.
Aaron, if you could play 22640.
Any unit not working the signal 33, go to Bravo.
So I got more students running west towards the football field.
Afroman is booked at Freedom Fest. Awesome.
I hear shots fired.
Shots fired.
Once again, shots fired. Is that a confirmation? And are they trained that means there's continuous shots being fired?
Yes.
Now, it says Juliet 3, we're going to Bravo. What is that?
You're going off the main channel to another channel, which is We'll need a dispatch to monitor, basically.
What's the main channel's called?
Main channel is a channel on right now, any officer, any deputy, any officer, where you're getting live updates, the dispatch is monitoring, all your resources are going to respond on main channel.
Is there a reason in this situation to go to Bravo channel?
You will not go to Bravo channel. Only units not addressing the current event. That's why she said, if you're not handling the situation, go to Bravo. Anyone involved in this situation will stay on main channel because everyone is coming on main channel.
Does that mean the first person on scene, first deputy on scene should stay on main, not go to Bravo?
Everyone has to stay on main channel.
Aaron 228.
Homburg shut down, went on to building 13 in the 900 building. We have shots fired. I'm trying to get the fence open.
Building 13 and 900 building.
Alex, do not approach the 12 or 1300 buildings. Stay at least 500 feet away at this point.
500 feet, at least 500 feet away. And what training is that?
We don't do that, sir.
What do you mean you don't do that?
There's active intel between the 12 and 300, the 13th building, 12.
12 or
12 or 13, you're going to respond to the stimuli. We don't tell deputies to stage back. That's indicative of what they did in Columbine, waiting. We don't stage.
And why is it important to get there as fast as they
Lives are being lost.
Is there any training, not active shooting, any training where it's taught to stay back 500 feet?
That I facilitated? No.
That you've ever seen?
If you knew the size of like a bomb, probably, but that's about it.
You mentioned earlier auditory exclusion and tunnel vision. Can you just explain what auditory exclusion is?
Auditory exclusion. Your focus of your hearing is tuned out. You're so ingrained. For instance, let's say you're watching, in layman's terms, let's say you're watching a game, a football game, or the Heat basketball game. You're so in tune, and someone's saying something you're not paying attention to it because you're so focused on that particular object, time, and object in front of you. And when, in the case of a critical incident, your senses, your hearing diminishes, but your sight on the particular target in front of you is your key focus. You actually start losing peripheral vision, your hearings diminish, and you see what's unfolding in front of you.
Now, as part of your training, learn ways to, let's say, shake that off?
In the firearm classes, and the active killer, or even in the self-defense classes, we tell them to basically, it's called tactical breathing. Take a deep breath, refocus. When we shoot the handgun classes, rifle classes, and we address the target, we're shooting the target, you get fixated on the target. So we'll say, hey, on the command of gun, you will shoot 5 or 6 rounds. You shoot into the target. You take a breath, pause, scan. While you're scanning, I'm breaking my tunnel vision. I'm no longer fixated on that particular target. I'm looking around my surroundings to gather other intel. Maybe somebody else is moving peripherally, maybe I'm hearing something, another command. That's why we do it. We do it in the firearms training, we do it in active killer training, we do it in defensive tactics when we do hand-to-hand combat.
So different ways, just to recap, I'm going to have you recap what you just said. What are the different ways to shake it off?
Take a deep breath. You take a deep breath and scan the area. Don't just look in one direction. Start looking. Some people say 360 awareness. It's actually more than that because you're looking around you, but you should also look up or look down because you might be walking into a manhole. You might get someone drop a brick on your head. Look around. Shake it off. Don't just fixate on one specific point.
So scanning, for instance, east and west would be a way to shake it off.
Shake it off.
Shake it off. Shake it off. Shake it off. Shake it off. Shake it off. Ooh, ooh.
That arrives on scene, and you hear gunshots. What are you trained to do?
Address the threat. Move towards the gunshots.
In a situation where you don't move towards the gunshots, and a second officer arrives, one with a more high-powered rifle, what are you trained to do in that situation?
We call it linking up. It's two of us now. Let's go. Let's do it.
What do you mean by that? Let's do it.
We're gonna hunt. We're gonna contact him. We're gonna find the
I'm not
shooter.
sure if I call it
We're gonna
hunting,
find
but
the
okay.
stimuli and force an outcome.
Now, in terms of training shots, how does it work in terms of whether a deputy hears shots or they hear, for instance, an SRO hears a fire alarm? What are they trained to do in either of those situations?
Address what's going on at a particular time. What's causing it? What's the causation of whatever's going on? Investigate it.
Now, once shots stop, what is trained? What are the deputies trained to do?
Gather some more intel. Move in. Try to get a better vantage point to see what's going on.
And is that going back to the training using your senses?
Correct.
Why is that important?
Because if you move and try to get a better vantage point, your senses will kick in and you get more intel that you can relay over the radio to gather more resources or give more intel as to how we're going to handle the situation.
Would you do things such as check windows?
Yes.
Or I'm going to publish. Not publish, I'm sorry, I'm going to show witness exhibit, Your Honor. Lieutenant Colonel, I'm showing you it's already been in evidence as states 16. Oh, you can, yes, you can show it. Yes, Your Honor, I apologize. Can you see that?
Yes.
Are these the type of windows that you would want to look into to gather intel?
Yes.
This is by far and away, for me, the most interesting testimony of this trial so far. And the state is doing a fantastic job with this witness. The state has been doing a really good job with all the witnesses, to be fair, but
Showing you what's already in evidence as
this is really good stuff.
Do you see the door here?
Yes.
Are those the type of windows that you would want to look into to gather intelligence?
Yes.
Yeah, it was a little slow on the intro,
What is round confirmation?
but, you know, fine.
If someone is shooting, it's going to hit an object, a person. You could tell a general direction where the rounds are coming from. If someone's shooting at me, I would look to see if they're shooting, if there's gunshots around me, hitting a pole, a car, a person. If there's no wrong confirmation, more than likely no one is shooting at me. It's a sound.
And with that information, if there's no round confirmation and you're still hearing shots fired, what are you trying to do?
See where the shots are coming from.
See where they're coming
Seek it. Find it.
from. Fine. Now, going back to that rifle refresher class. In 2018, I mean, to take this class, you have to have been issued a rifle, correct?
Correct.
Okay. So looking at number 7, patrol rifle refresher, Halloween of 2017. With an SRO being issued a rifle in 2017, do you know where they were kept?
No. During that time period, you would issue one, you purchase one. So more than likely where the deputy who has a rifle, they either have it in their vehicle at that time.
Okay. So being in their vehicle, a rifle in a vehicle, how are deputies trained to keep rifles in their vehicles?
At that particular time, there were rifle racks. And the rifle rack is between the front seat, between the driver and the passenger seat, mounted against the cage in the unit. Or if they had a Pelican case enclave, they could have it secured in the trunk of their car.
Pelican case would be more like a lockbox?
Correct.
You know, in a situation where a deputy determines that they want their rifle in a situation like this, what are they trained to do?
As to what, obtaining their rifle?
Correct.
You go back to your vehicle, sling the rifle on, because the rifle is in a sling. That's one of the mandates. So you can free your hands up. The rifle's in a sling, so you sling the rifle over you, and you could run with both hands, or you could transition to your handgun. You could go handgun, hands on the person.
Well, with that said, given the training on the tactical handgun, SROs are armed with a handgun.
Correct.
Yeah, we're still on direct. I have a feeling we're going to be on direct for a while. I have a feeling like we're going to use this witness for all the things. Because this witness can do all the things. I feel like we're going to be on direct for a while. This could go on for days. Oh, my little banner went away. That's annoying. Why did my banner go away? Oh, I took it down during the break. That's right.
Senator Brown, just a couple of questions. In terms of the school resource officers' responsibilities, are they the quote gatekeeper of the school?
Their primary job function is to protect the kids at the school.
And actually, you could just answer the second question. Now, the video audio that was played, you reviewed that in its entirety, correct?
Yes.
Now, in your experience, or based on your experience, based upon the training you've received, based upon the training that you've taught, the training that you've reviewed and approved, were the defendant's actions that day consistent with his training?
No, it was not.
Why not? What should have been?
Some type of proactive action.
What does that mean, proactive action?
Go towards the sounds, investigate. That's expected. You're first in scene. You got to make a decision. It doesn't matter what position, rank. If I was here and shots are being fired and there's no one in the courtroom, I have a duty to act based upon my training from Broward Sheriff's Office to respond. We all train that way, to respond to stimuli, which is gunshots being fired, which entails that victims are dying to do something.
The things that could have been done. Does that include going into the building?
Yes, sir.
Does that include yelling out sheriff's office?
Anything to disrupt the OODA loop of the shooter.
So anything to distract the shooter?
Correct.
In any of the training that you reviewed, approved, been part of, or taught, were you ever trained to stay during an active shooting situation in the same spot for 48 minutes?
No, sir.
What is cover and concealment?
Cover and concealment is when you're taking live fire. If someone's actively shooting at you, you stand behind a column, a building. Cover would be something that could stop a round. Concealment will be against this wood partition. It's not going to stop a rifle round. If I'm taking rounds, I want something solid. Engine block, a concrete pole, something could just slow a round down, basically.
How does that work in conjunction with an active shooter?
You seek cover if you're getting live fire. If not, you make movements towards the target or the threat.
And if you're taking live fire, you're trained
I'm
to
taking-
see what over dispatch?
I'm taking live fire, I'm being shot at.
Just an update on the Twitters. You guys have done 33 retweets so far. Thank you very much. If we hit 50 retweets, I'm going to donate 20 memberships. So make sure to hit that retweet. Help to spread word of the channel.
You pair up with another officer. What are you trained to do in that situation?
When you pair up, you're seeking the threat. We have a technique called plate to plate, so it basically means go back to back. As I'm going down the hallway, if there's a door, I'm crossing a door, I am facing forward. My sole responsibility is looking forward. The secondary person, they will be on my arm with their firearm pointed at this door. So as I focus forward, they're crossing the door, addressing the threat. That's what it is basically. We're clearing areas, open spaces.
Really? Okay, we're not using this witness for all the things. I'm surprised we're on cross, but okay, let's see what we got. I thought this direct would go on for 2 days, man. I thought we were going to use this witness for all the things. I guess not. He's a really good witness, too. I'd want to use him for all the things. Why not? He's a good witness. Use him for everything. All right, let's see what you got on cross. This will be interesting.
Good afternoon, sir.
Good afternoon.
Your Honor, the first thing I'd like to do is I'd like this witness declared an expert in training, police training, based on his experience. Yeah.
Okay, this is interesting. So defense wants to qualify him as an expert. Interesting. So it's interesting. Okay, so one of the things that's interesting technically on this is that technically by rule, cross-examination can only be as to the questions that were asked on direct. Now, there are a lot of questions asked on direct. So I'm not sure how much that's an impediment, but some judges don't mind as much. Some judges will let you cross openly, and some judges don't. It's like if you want to make him your own witness, call him on direct. It depends on a little bit of the judge's temperament. So some of the objection here might be based on the nature of the questions that they anticipate asking, but he's like, let me get him as an expert because I'm about to ask him opinions. Because the lawyer learned from the previous experience with the previous witness about the whole opinions thing and getting lambasted. So first thing, let me declare him as an expert. Interesting. It is a little unusual to have someone who's both a fact and an expert witness, but it's not unheard of. That could also be based on Florida rules in terms of that. So I don't know Florida rule that well, but it's a little unusual technically. But interesting stuff. It'll be interesting if they don't let him be certified as an expert, their own person, right? So it's like, okay, so you're not an expert. So I suppose even if he loses, he wins a little bit because they're like, okay, well, the state admitted that he wasn't an expert. So what does he know? So, maybe it's a win-win proposition. If he's an expert, I get to ask him opinion. If he's not, I get to say, well, he's not an expert. Even the state admitted that he's not an expert. So what does he know? Could be. I don't know. Interesting for sure. I'm not sure exactly.
Agree that you consider yourself to be an expert on BSO training, policies, and procedures, correct?
Yes, sir.
Okay. And one of the things that you left out from your distinguished law enforcement career is that you actually went to college and you graduated, correct?
Yes, sir.
You got a degree in criminal justice, did you not?
Yes, sir.
And you attended the fine University of Northwestern, correct?
That's incorrect. Your depot on me, it was misprinted.
Oh, so what's the school? I'm sorry, it said Northwestern, right?
I know, sir.
But that's not?
No, sir. Your depot is actually incorrect.
So where did you go to college?
Polk State, sir.
Okay, fair enough. So that was something the court reporter would have put down as
Yes, sir.
Northwestern. You never said Northwestern.
I said Northwestern as to executive management training.
I got it. Okay, so just a typo. It wasn't something I did, correct?
No, sir.
Okay, good. All right. Did you ever have the chance to speak with my client after the shooting?
No, sir.
What is a debriefing? What is that?
The briefing is getting intel or asking the person who was involved in the incident information regarding.
So he's not an expert?
And when you conduct a
Or are you
debriefing,
further vordeering him as to expertise?
specific.
Because when you asked about college, it sounded like you were going to further. Is he not an expert?
Incident at that particular time.
I'd love to know the basis of that ruling legally. That'd be very edifying for me.
Correct?
What they're thinking, what they saw, whatever intel they got from that particular moment.
Right. It's kind of similar to when anyone of us as non-officers really want to find out details from somebody. You're asking what happened next, what's the next thing you did, correct?
Pretty much, sir. Yes, sir.
All right. You are familiar with the Broward Sheriff's Office Department of Law Enforcement Standard Operating Procedures involving an active shooter, correct?
At that particular time, yes, sir.
All right. And that's governed by 4.37, correct?
The chapter, yes.
All right. And you are familiar, are you not, with this? Let me just ask if I can approach. I've shown the state this already. It's Defense Exhibit H. If I can approach the witness, Your Honor?
Sure.
Okay. Just take a look.
Maybe
at
it's
that.
because of the
Tell us-
blend of fact and expert witness. Maybe that's the problem.
The PSO active shooting policy that was in effect at the time of the shooting.
Yes,
or
sir.
no? Okay. Thank you. Just highlight some things. There is a, Your Honor, if I can have this.
That item is on evidence.
Does this fairly and accurately depict the active shooting policy that was in place during the shooting?
Yes, sir. Based upon the date at the bottom right-hand corner. Yes, sir.
Would now, Judge, we'd now like to publish this to the jury.
You want to move it into evidence?
Yes, sir.
State any objection? All right, so without objection, defense H for identification will now be in evidence. That's defense exhibit 2.
Okay, so we're going to try to nitpick over the policy to show that what the defendant did was actually within the policy. Okay, let's give that a shot. I mean, they nitpicked the contract to look for any mention of student.
4.3, you're familiar with that section?
So are we going to nitpick the policy? I guess.
Yes, sir.
And it has to do with debriefing, correct?
Correct.
And by the way, policies and procedures regarding active shooting, it's not suggestive, meaning it's not an option. They must be followed, correct?
Policy is a guideline, it's a recommendation. Based on totality of circumstances, I personally would violate policy to save a life.
Okay, so regarding debriefing, it says here that the incident commander will be responsible for conducting a debriefing of all personnel involved in an active shooter situation in a timely manner, correct?
Correct.
It also says it's to learn the successes of the response and identify any needs for improvement, correct?
Yes, sir.
All right. So you weren't the incident commander, correct?
No, sir.
So whoever the incident commander was, they're responsible for investigating and speaking to those who were involved in an active shooting, correct?
Correct.
And it's to find out in detail what they were thinking in real time, correct?
Correct.
What they knew, what they saw, what they felt, correct?
Based on that event, yes, sir.
Because it's so important to know how to, in the future, change responses, correct?
Best practices, yes.
To improve best practices, correct?
Yes, sir.
36 tweets and retweets. You guys are kicking ass.
7.3, under debriefing, subsection B, that the incident commander will complete an after-action report, correct?
Correct.
That's after the debriefing.
I'm going to go ahead and schedule the afternoon session as well.
Are spoken to in detail. An after-action report is supposed to be completed.
I'll put in a placeholder for the time because I don't know the exact time, but I'll put in a placeholder.
Done in this particular case?
Not to my knowledge, sir.
Did you ever insist that anybody does a debriefing of my client?
At that particular time, it was not in my purview in the training division.
Okay, so just not your job, not under your.
Correct, sir.
Okay.
Nice.
Did you ever speak to any of the officers who were on the scene that day?
No, sir.
So you've never debriefed them to find out what their real-time intelligence was?
Not
correct?
until after it was an active investigation, so I was hands-off, sir.
So for example, Deputy Kratz, did you ever speak with him about what
No,
you
sir.
saw? You ever speak with Lieutenant DeVita?
No, sir.
Have you ever spoken to Officer Burton?
Coral Springs? No, sir.
Yes. What about Officer Best?
Okay, this is
These
interesting.
guys?
No, sir.
To understand what they were thinking, what they were feeling in real
This
time?
isn't bad, Cross. It's not bad.
Did you ever speak to
Show for any
of the
deficiency
kids
you can find. Show any weakness you can find.
in the
Works for me.
700 building and who heard shots in real time to understand what they thought?
That would have been an investigative division, sir. It would not be in training, sir.
So the answer is no, correct?
Correct.
Did you speak with any other kids who were outside of other buildings during the fire drill to understand what they thought about the shots and where they thought those shots were coming from, sir?
No, sir.
Now,
I mean, I'm not really sure it's particularly material, to be honest, but you find anything you can get.
First of
So,
all, we're talking about a building, right?
Yes.
From end to end, please give us an estimate of how large the building is, correct?
Probably
Castle Rock does not apply because Castle Rock only applies to civil law cases.
or more.
And this is a criminal case.
Yes, depending on its.
I'm horrible at math. How many yards is that?
Well, a yard is what? 3 feet?
Yes? Also about a meter?
I'm guesstimating. I haven't been in a while. Maybe almost a length of a football field, a little shorter.
Okay. That's the confines of what you're talking about. One building, and you're saying it's about footballish field. That building's that big? Is that what
Yes.
you're saying? Okay. How many floors in the stockade?
One.
One floor building.
Yes, sir.
Okay. There are no neighboring buildings that you're utilizing, it's just a stockade, correct?
Correct.
And everybody knows that the shooters.
Showing that the scene of the incident is not the training environment. Fair.
And the issue is, okay, go in, and once you're in.
I mean, it
know
never
there's a
will
shooter
be,
in the
but,
stockade,
still.
Go and find them, correct?
Correct.
Do you ever use any training mechanism where you're using multiple buildings as large as a stockade in addition to the stockade? You understand what I'm asking?
Yes,
Do you ever do training like that?
we did. We used schools. We've done Port Everglades.
Okay. And do you ever have a scenario where officers are on a scene and there's shots fired from somewhere that nobody knows, and you have to go try to find in a multi-100-yard area where the shooter or shooters might be located?
Well, for safety reasons, first of all, we have to confine to a building.
I got it. That makes sense. It's also rare that you would ever, if ever, have a scenario where you have no real-time intelligence of where precisely the shooter's located over an area that spans multiple football fields, correct?
Well, Port Everglades, sir, it actually spans. We use multiple floors, and you follow the intel. The best we could do is simulate. The concept of active shooting is not building specific. Your environment is going to dictate your tactics.
I understand that, sir. My question is regarding, first, we'll get to all that. I want to know whether you've ever trained in an area, and I'm showing you what is marked as Defense Exhibit F, okay?
Right.
If I can get close to the witness, Judge? Sure. Thank you, sir. A scenario.
Mr. Aguilar,
Yeah.
over on this side, sir.
Like this?
No, sir. I can't have you in the jury box, and I can't have you in the witness stand.
Just
Right over here, sir. Just like we've done with every other person who's seen the state's exhibit. Go ahead, sir. If you would like the witness to step down.
If you could, have you ever had a scenario where you have training in an area that is at least a football field, plus another football field, plus another building that's 73 yards long, plus about 20 yards of a courtyard area?
Not bad.
Plus another 73.
It's a little
yards long,
nitpicky,
plus
but,
another football
you
field
work with
area.
what you
I
got.
add that up, but we're we're talking about
He's a good lawyer.
multiple football fields.
I like this
plus
guy.
Up north, up south, that would serve as the geographical area of where a shooter or shooter might be located. Have you ever had a training scenario like that?
And my answer would be no, because it's not feasible.
Got it. And I'm not blaming you.
Right.
I'm just saying it's never been done, correct?
Well, on a larger scale.
I got you. Or you can have a seat.
With SWAT.
I got you. But now it's regular officers.
Correct.
Or a school resource officer, correct?
Correct.
Your scenarios deal with, you know there's a shooter inside of a building, so you just need to find where the shooter's located, correct?
Correct.
Got it. And you brought up Columbine, you brought that up when you were talking to the prosecutor, right?
Yes, sir.
Columbine, that school, there was a building, and the officers allegedly knew that the shooter was in the building, correct?
Yes.
And then they didn't go in, correct?
Correct.
Not bad.
So intel is everything, right? What you know in real time is critical, correct?
Yes, and you're supposed to seek it out. That's why.
I got it. We're going to get there, sir. But clearly, it's important.
Good job on maintaining control of the witness. You know, yeah, I understand. We'll get there, but maintain control, getting answers to your questions.
To what was found out after.
Good job.
Correct?
Objection, Your Honor. I have a couple questions. Yeah, that's sustained.
So, one of the reasons why you have a debriefing is to know what somebody knows in real time as opposed to what they learn after the fact, correct?
The briefings it'll be after the fact. In this case, after what occurred, what could we do better? It actually said in the policy that you showed to me.
Correct. So in a debriefing, you find out what the person knew in real time, correct?
At that particular time, yes.
And what information was ever given to them in real time, correct?
Correct.
So for example, if officers are not getting real-time intel as to precisely which building a shooter or shooters may be located, you want to do better and fix that problem, correct?
Correct, but can you define real time?
Well, what's your definition
Real-
of real time? So we're on the same page.
You're saying that the person on scene is getting intel. The person on the scene is the intel because they're using their sensors to obtain information at that particular time.
Okay. They're also seeking out information from dispatch.
Can I turn down my mic a little bit?
Well, the dispatch can't give you if you're.
I'll forget to turn it back up.
The sole response. You're the first person on the scene. You are the.
I guess you'll just have to deal with me talking and it being loud, but you've got subtitles. We'll make it work.
Other officers are arriving on scene, and let's say one officer saying, "Shots fired by the football field." Isn't that officer relaying intel?
Your problem is that you're trying to adjust your sound audio. That's your problem.
So
Yeah.
numerous people can relay intel to the dispatcher over the radio, correct?
God damn it.
And
Fine.
then the dispatcher can then hear that information and then announce over the radio what they're hearing, so other officers can hear it, correct?
Correct.
All right. I've reset my
Having
audio to
a radio
20%,
that's
so hopefully it'll be more
functioning
consistent
properly
and you
is
won't have to
critical
keep
when you're
adjusting your
reacting
volume.
And responding.
And I'll just have to try to remember to set it back.
You have firsthand knowledge that that radio system was a colossal failure to the BSO officers during the shooting, isn't that correct?
Yes, sir.
And you didn't just learn that day. Those complaints had been coming in.
Yeah. So I reset my
Well
volume to
before
20%. So
this
now
active
hopefully you
shooting
won't have to keep
scenario,
messing with the
correct?
volume up and down.
That was my purview again. I'm training. I have nothing to do with ITD or communication, so I can't attest to what the radio transmission capabilities were at that particular time in the city of Parkland.
You knew those radios were a colossal failure before this day. Didn't you know that?
Sir, again, I would not know because I've never worked in the city of Parkland. I've worked downtown or in central Broward, so I never had an issue with a radio.
But you would tell them that it is essential to have working, functional radios when you show up to an active shooting situation, correct?
I agree with that, sir.
It's also critical to have real-time intelligence.
I don't like that he's a little shouty.
We're calling in to 911.
I mean,
correct?
maybe it
Yes.
plays better in the
Did
courtroom,
you
so I'm just
know
being unfair.
that the 911 calls being made by frightened children inside that building went to Coral Springs and not to BSO?
Maybe it's an unfair criticism on my part.
You didn't know that?
After the fact.
You learned
Yeah,
that?
Sandra,
Yes,
remind
after
me
the
if my volume is off to readjust it, because I did that whole
Whose idea
recording.
was it to allow the
With bad
911
audio, 'cause I
calls
forgot to reset
go to
it.
Coral Springs and not go to BSO? Who made that decision policy-wise to begin with?
Sir, I don't follow your question.
You have learned, you said, that the 911 calls that people are making while they're inside the 1200 building, that went to Coral Springs and not to BSO officers like my client, correct? You already conceded that, right?
Okay.
Before the shooting date,
Okay.
who was responsible for
I'm getting a
creating
sense we have a little
policy
hostility
where
here.
those
Oof.
calls only went to Coral Springs and not to BSO?
Again, it wouldn't be my purview. I wouldn't know, sir, who made that policy. And just to let you know from personal experience, when I was a commander in Pompano, if someone was driving west on Southgate Boulevard, which is near the city of Coral Springs, their call gets relayed because of the cell tower to the city of Coral Springs, and then that call is transferred to the city of Pompano.
Right. But that's not what we're talking about here.
And again, it's not my purview to explain. I don't understand why
That's
the calls
fine.
are routed.
If you don't know, you could simply say you don't know, like you're doing. That's fine. Okay. Do you
Ouch.
know
Ouch. You don't
whose
know what you're doing.
responsibility
Ouch.
when you're on a
Hostile.
scene
Hostile.
to ensure that the radios are patched?
You don't need the witness to be even more hostile, do you, than they already are? Damn.
What human being, what person would have been responsible for ordering the radios to be patched so that the information that Coral Springs is getting will then be on BSO's radios?
That's, again, it's not my job purview. I'm not familiar with the communication radio system.
You are aware that the radios were never patched during that shooting, correct?
After the fact, sir.
You learned it after the fact.
Yes, sir.
But you would agree as a training officer with your history that when radios are not patched, that would greatly hinder my client who's trying to get real-time intelligence while he's on the scene. Yes or no?
It would help in getting real time. Yes, you're right.
Oof.
Now, you've stated correctly that if you know where sounds of gunfire are coming from, you move towards them, correct?
Yes, sir.
We can all agree that that's what you're trained to do.
Correct.
Okay, so let's assume that you get as close as you possibly can, but then you don't know where to go. Okay? And that the possibility of where you hear gunfire comes from is covering an area that literally represents hundreds and hundreds and hundreds of yards, correct?
Okay.
You understand that scenario?
Yes, sir.
You've listened to gunfire for 4 minutes and 15 seconds, and you still think it's anywhere in this area, correct, sir?
Yes, sir.
What are you trained to do, sir?
Start seeking out where the gunfire is coming from.
Okay. So, in a scenario like this, where any one of these scenarios could be equally plausible, where do you start?
Well, you start where you're standing. Process of elimination. Keep moving. Every time you hear a barrage of shots, that's more intel, and it's process of elimination of buildings.
Okay, so do you start, again, you say buildings. There's a parking lot to the right, which is equally in play, correct?
Correct.
And assume that it's the size of a football field. Do you just go to the right and start at the closest place, I guess, which would have been, the right would have been the parking lot? You're supposed to start there?
Well, you depending on one sense, sir, there's a sense of sight and smell and observation.
Yeah.
And I believe in one of the videos I reviewed, I saw people fleeing out. So that's one you could use your sight, like it's a clue. If people are fleeing from a building, I would say to go to that building and try to find what's coming, what's called that stimuli to make people leave that building.
Did you just tell this jury that you saw a video showing kids leaving the 1200 building
I didn't say
during
that.
the shooting?
I did not say that, sir.
Okay.
I said if you see someone running from a direction of a building,
Sure.
you would assume, based upon your senses and your training that we replicated at the stockade, that's a good reference point to start in that general facility.
Okay. So if kids are running out of the 700 building, for example, and running back in, should he run over to the 700 building?
Ask questions.
Okay. And assuming, by the way, that you believe that the area on campus is unsafe, and by that I mean that there could either be shooters, multiple shooters, wandering the campus shooting their guns, or potentially sniper fire from any of the neighboring areas. Isn't it prudent to make sure there's fewer kids and parents coming onto campus, especially when the school day is about to get out?
Well, so you're based upon intel. Are you seeing, you said sniper fire, are we seeing round confirmation? Are we seeing victims? Are we hearing gunshots? Are we seeing debris? It was said on the radio, like the tape is displayed, I think several times, that it was in or beside the 1200 building. So that would be a great place to start.
Okay, so back to my question, okay? Assuming that my client believes that there's gunfire anywhere in this area so that there could be harm to parents and children who come onto the campus, isn't it prudent to do everything you can to keep the parents and kids off of the campus? Yes or no, sir?
No, based upon the priority of life. We just said it, contact team. If live intel is being shot, my first priority is to go towards the stimuli of shots being fired.
So the opposite would be true then. You believe that if my client thinks that there's shots being fired on campus and he doesn't know where they're coming from, to invite and have parents and kids come onto this campus? Is that what you're saying?
I'm not saying that, sir. I'm saying based upon the stimuli, shots being fired, your duty to respond, based upon training, is to seek a
Nachos
shootout.
does sound good, but
There's
steak sounds
additional
better.
units
I like
showing
steak.
up.
Steak is good in my tongue.
But the thing is, sir, I understand what you're saying. What I'm saying to you,
Then
sir,
can you answer it, please?
I'm answering your question. Should we stop the parents? No, seek a shooter. The parents are not being shot right now. We know people are being executed. We have to stop it.
Okay, back to my question, and just laser focused on whether parents and kids should be allowed to enter the campus when my client believes that there's a shooter or shooters that could place them in
Hey,
jeopardy.
Vices is doing a raid.
Don't
Thank you so
agree
much.
with me
Lorax for the
that
nice
it's
raid.
best
I
to
really
keep
do
them
appreciate
off
it.
of campus
We've got a
so
little
they
thing
can
going
be
on, by the
safe?
way. If you
Yes or
retweet
no,
the
sir?
pinned comment
Sir, again,
and we get to
no.
50 retweets,
Priority is
I'm
the people
gifting
who are
some
being
memberships,
executed at
and
that
we were pretty
particular time.
close.
That's my
We
object.
are
That's
at
my main
36.
focus.
So if you can
I understand
retweet
it
that
takes
pinned
a couple of
comment,
announcements on your
I'm
radio
gifting
to say,
some memberships
"Let's
at
get the
50
school
total
locked down.
retweets.
Let's get it locked down so parents and kids don't
Thank you
come
for
onto the
joining
campus."
us.
It takes seconds to do that. You don't think that that's consistent with your training to keep people away so the scene doesn't become complicated and so the kids and parents aren't harmed?
You could transmit and move. That's been taught.
We'll talk about the movement. Again, we're focused on my client getting on
I
here
like
5
it. The
times
lawyers
saying,
like, let me
"Let's
focus
lock
on my
the
question.
campus down."
Right? It's not asked and
Isn't
answered
that a
until you actually
prudent thing
answer
to
my
do and
question.
consistent
It's
with
like, let's
training
try this
so that
again.
parents and
We'll keep
kids
doing this
don't
until
get
you actually
harmed
answer
as
my
they come
question.
onto this campus, sir?
If-
Object to ask and answer.
Yeah, that's sustained.
I will know. I think I'd overrule it.
Chris, pause.
I'm not sure it's over.
So, ladies and gentlemen, we're going to pause the cross-examination at this point. I'm going to send you.
Oh, we're going to take lunch?
Same, admonition as
Aw.
always. Please don't
Well, I'll give a
discuss
summary
facts
for the
like
law
daily
recs people.
witnesses or the testimony amongst yourselves or anyone else. Until we reach the end of the case, I'll tell you when that is. I hope you have a nice lunch. You leave your notepads in your chairs. They'll be waiting for you when you come back. I'll see you back at the jury room at 1:50 p.m., 150.
150. I think I scheduled it for 12:45, so I think I'm on the money. I schedule it for. Yeah, 12:45. Got it perfect. Not bad for guessing.
Okay, we're outside the presence of the jury. Everyone can be seated. State anything you need me to address before we recess for the lunch break. Defense, anything you need me to address before we recess for the lunch break. Okay, I hope you have a good lunch. See everyone at 1:50
Thank you very much for the
p.m.
gift memberships.
I'm going to see you back here at 1:50 p.m. You can talk to anyone you want about anything you want except your testimony in this case. Just like you're on the witness.
Yes, sir.
See you at 1:50 p.m.
All right, cool. Very, very cool. All right, so let's give a summary of what we're doing so far. Thank you, first of all, for all the people joining us from Legal Vices, the Law Racks channel. Really do appreciate that raid. Thank you so much, Jeff. That's really kind and thoughtful to all you guys. And let's discuss a little bit about this case because some of you might not be familiar with it. So we'll go back to the basics. All right, so the shooting in Parkland occurred February the 14th of 2018. The school shooter has already been tried, convicted, and sentenced to life in prison. 14 students died and 14 students died and 3 adults were also killed. Also, 17 students were injured. It's one of the more serious mass shootings in our recent memory. The shooter, of course, having been convicted but not getting the death penalty, I think left some people a little unsatiated. So the school resource officer is being charged as well, essentially for cowardice, but legally for negligence that led to the death of a child and to the death of the adults. So this officer is a fully licensed badged police officer, the same as any other officer. His duty station is the school. So as opposed to being a police officer who walks a beat or rides in a patrol car or whatever else, this police officer's duty station is the school. He's been a school resource officer for a number of years, the previous 9 of which, before the incident, he was a school resource officer at the school itself. The school is huge. It's 45 acres, 3,000 students, multiple buildings. The buildings are the sizes of football fields. There are football fields on the campus. There are parking lots the size of football fields. It is a huge building. It is a huge campus. It is a lot of students. And it appears, based on the testimony, that he was the only officer on site during the shooting. The testimony has been slightly unclear that maybe possibly some officers were there at the extreme tail end of the shooting. But principally, for while the shooting was occurred, he was the only officer on site. So far in the testimony, what we've heard principally has been from a rotating group of students, teachers, and other police officers who responded to the scene, as well as detectives who found shells and so forth and so on. Basically, the testimony up to this point has been primarily emotional in its nature. The students have shown their wounds, they've shown the bullet holes that pierced their body and pierced their legs, testified to the shots, how they were horrified, the trauma of hearing the shots, waiting for the officers to come who would never come, and how it went on forever. They're testifying how they lost friends, the faculty members testifying about how they lost colleagues and lost students, the detectives talking about the rounds that were recovered, and we also heard from the medical examiner as well who did the autopsies. So principally, it's been very emotionally focused up until now. This witness has been the best in sort of understanding the facts of the thing. This is a lieutenant colonel who works in the sheriff's office, and he does principally, it seems, training. And he does a lot of training. And he's testified as to Scot Peterson's specific training because they keep records on such things, have kept records at least since 1999. So they have a very thorough record of all the trainings that he's engaged in, the defendant, what he's done. And some of those trainings that I think the witness himself actually provided personally, as well as being familiar with the training protocols in general. So talked a little bit about tactical pistol, talked a little about specific training relating to schools, talked a little bit about trainings that they've done, for example, in abandoned or former jails, so hardened concrete surfaces that are somewhat comparable, at least in that respect, to the school in terms of echo, in terms of blind spots, in terms of lots of area to cover, in terms of other things like that. So getting a lot of that testimony from him. We also briefly discussed the contract that exists concerning his being designated to the school, but it was very brief and just basically was a highlight of please show us every time the word student appears, and also the fact that you still have the duties of any police officer. So a little bit thin. If we're trying to get legal duty through contract, we didn't really get that from this guy. We nitpicked specific parts of the contract that were sort of on point, but really not. So if we're trying to use the contract as the basis of legal duty, I was not sold. We also got from this police officer just general ideas of how they conduct training, what kind of equipments they use, how radios are used, communication, and also how after post-Columbine that they're trained to go towards the shots of gunfires and not wait for backups. So that is what we have. As to what the defendant himself personally did, a little bit unclear. We have heard allusions to the idea that the defendant perhaps sat behind a car or something for 40 minutes, but we don't actually know that because no one's actually testified to it. They ask questions in cross or redirect, rather. They ask in redirect. So, like, is one of the things that you would do hide behind a car for 45 minutes? No. But we don't actually know that's what the defendant did. We have not actually heard any testimony about that. Apparently, there's a tape that exists, but we haven't seen the tape, No one's testified to the tape. So we're not very clear on what the defendant actually did or what steps he took. All we know is what he didn't do, but that doesn't speak to what he did do, right? He has to execute his, assuming for the moment he has a duty, assuming for a moment he has a duty, he has to go about executing that duty in a reasonable way under the circumstances, which could mean a lot of things. Just because he wasn't tending to particular children doesn't mean that he wasn't doing something else that would be within the scope of his duty. You know, maybe it's a triage kind of thing for comparison. You know, it can only be one place at a time. So what was he doing? Was that furtherance of his duty? A little bit unclear. Also, it appears that we're trying to charge him essentially as a caretaker, like he's a parent or in a similar position. Parents do have affirmative duties to their children. They have a duty as caretakers. They have to feed them and clothe them, take them to the hospital, make sure they don't starve, so forth and so on. So parents sometimes get charged for not doing things. For example, letting their child starve to death because they didn't feed them or things like that. It's happened, right? So yeah, you can charge a parent for not doing things. So we're trying to essentially, and teachers, I understand, under Florida law, are understood to be caretakers. This is my understanding. I haven't read the underlying case law, but this is my understanding from reading articles about it. The teachers are understood to be caretakers, at least to some limited extent. So unclear, though, how that relates to the police officer, how he's a caretaker. And the defense has certainly highlighted ways that he's distinct from a caretaker. He's not required to make sure the children eat, not required to help them with nutrition. He doesn't look over the children on a regular basis to check for signs of child abuse or neglect or anything like that. You know, if it comes to his attention, then so be it, but he doesn't, you know, normally take on those roles. He's not responsible for clothing them, feeding them, taking care of them in a normal sense. So in what sense is he a caretaker? Unclear. The judge appears to be allowing this to just be decided by the jury as to whether or not they're a caretaker, which seems like a question of law. So even if he's convicted, I imagine there will be appeals on the issue because I'm not sure it's viable as a matter of law. As to whether or not cops have a duty to protect and serve, the Supreme Court of the United States has spoken to this in a civil context. There are cases like Gonzalez versus Castle Rock, or Warren versus DC, or Winnebago versus DeShawnee. 3 cases of note. One of those is only DC Circuit, by the way. 2 of them are Supreme Court, but still. They're the big 3 that I'm aware of. And those all speak to a civil context. So if we were trying to sue the police officer, then not so much, because there's no affirmative duty, right, under the relevant law. But this isn't a civil law case. This is a criminal law case. And so we're trying to charge him criminally. So those cases don't seem to apply. In the U.S. Supreme Court, the precedent doesn't seem to apply. Also, incidentally, for the same reason why qualified immunity is not an issue. Qualified immunity is only a civil law concept, not a criminal law concept, so doesn't come into play. God damn it, audio issues. Well, yeah, fuck it. Now I have to turn my mic up. Yes, because we've been dealing with the court audio and the court audio being really low. So that entire rant you just didn't hear. That entire explanation you didn't hear because it was really quiet. Fuck me. Fuck me. Because I had the audio down to deal with the fact the court audio was really down. And now that there's no court audio, my volume is really, really low by comparison. I hate my life. I hate my life. So, all that stuff. You heard it perfectly well? Great. Fantastic. I'm glad you did. Because the volume was really, really low. We have 41 tweets and retweets from this morning, by the way. I'm still counting, even though there's not much for you to retweet for. So if you guys retweet and you get 50, I will give you some gift memberships. So I'm still talking to give some of you guys from Legal Vices a chance to tweet and retweet because I want to keep my promises. So fine and exciting. Also, the U.S. Supreme Court released some decisions today, but we haven't had a chance to go over them. And I'd like to eat. So we could go over them now, and then I could eat during the cross-examination, I guess, and go off camera. So we could try that. Do we want to do some U.S. Supreme Court during the lunch break? Do we want to try to squeeze in 3 U.S. Supreme Court cases? Let's do that. Let's do that. Yeah. 99% of you heard it fine. Great. Before I move on to U.S. Supreme Court, are there any other cases or any other issues about this case? I feel like I've summarized it pretty well. We don't have a lot of information as to what the officer did. We don't have a lot of information as to duty. The charging him under a caretaker seems deeply questionable as best. Yeah, that basically summarizes everything. Let's do some U.S. Supreme Court. Let's do something productive. All right. All right. For today's case, we take a look at a recent U.S. Supreme Court decision that deals with Indian children, children of Native Americans. Federal law exists on this issue in relation to tribes that attempts to give primacy as it relates to adoptions to Indian families, Native American families. First to the tribe, if possible, and if not, then to other tribes that might be comparable. This has been an issue, obviously, as it relates to adoptions, because some people might want to adopt the Indian children, but they have to deal with the fact that these children have primacy with tribes, and so it becomes difficult for some people to adopt, even if they have a close bond with the child that's been developed through some sort of foster care, for example. So the Supreme Court has taken a look at this issue as it relates to Indian children, Native American children, and the adoption issues, and spoken to this issue. So let's read and understand what's going on in this case. Let's get started with this. This case arises from 3 separate child custody proceedings governed by the Indian Child Welfare Act, a federal statute that aims to keep Indian children connected to Indian families. The act governs state court adoption because, federal primacy on the issue. The federal government, by the Constitution, has the right to govern the tribes. So federal primacy in this domain, probably not a problem because of the Constitution. And so there is a federal law and foster care proceedings involving Indian children. So state law and foster care law will bend to federal law in this particular domain. Fine. Among other things, the act requires placement of Indian child according to the Act's hierarchical preferences, unless the state finds actual cause, which is pretty difficult to find in reality. Under the preferences, Indian families or institutions from any tribe, not just the tribe, which the child has a tie, outrank unrelated non-Indians and non-Indian institutions. So first, the tribe. If not, any tribe. If not, then other people. That's what we're doing. Further, the child's tribe may pass a resolution altering prioritization order. So if the tribe wants something different, then that's fine because the law allows for it. The preferences of the Indian child or the parent generally cannot trump those set by statute. So even if the parent wants something else, the federal law says no, because the federal law says this is what's in the best interest of the child. So the parent's wishes to the contrary will bend to the statute. Fine, that's what's going on. In involuntary proceedings, the act mandates that Indian child's parent or custody and tribe be given notice of any custody, as well as rights to intervene. So if the parent wants the adoption, then great. If not, if the child is being trying to be taken from them, for example, by them being an unfit parent, for example, then they're entitled to notice, as you would kind of expect. So they have to be given notice. The law requires the party seeking to terminate parental rights or remove the Indian child from an unsafe environment to satisfy the court that active efforts have been made to provide remedial services and rehabilitative programs designed to prevent breakup of Indian families, and the court cannot order relief unless the party demonstrates by heightened burden of proof and expert testimony that a child is likely to suffer serious emotional or physical damage, even if the parent or Indian custodian retains custody. So yes, this is designed to be and is harder than a typical removal procedure, because the federal government, which has the right to govern relationships with the tribes by the Constitution, thinks that it's particularly important that Indian children be kept with fellow Indians, or Indians of any description, really, and also is concerned, in particular, that children might be taken away from their Indian parents because of differences in culture that aren't necessarily problematic for the child, at least in the traditional sense of the Indian relationship. So the burden is higher. It's designed to be higher. That's the way the federal government wants it. Even in a voluntary proceeding where the parent is totally cool with everything going on, the biological parent who gives up the Indian child cannot necessarily choose the foster or adoptive parents. So if the parents are like, yeah, cool, adoption's fine by me, but federal law still is going to intervene over here, the child's tribe has a right to intervene at any point in the proceedings to place a child in foster care or terminate parental rights, as well as a right to collaterally attack any state's custody decree. So the tribe gets to be an interested party and intervene in the lawsuit as a party. Fine. The tribe then therefore can sometimes enforce the placement of the acts against the wishes of one or both parents, even if the child is already living with a new family. So both parents are like, cool, this is fine by us. Foster parents are like, I have a super strong bond with the child. The acts over here like, we don't give a shit. Okay. Finally, states must keep certain records relating to placements and transmit to the Secretary of Interior all final adoption decrees and other specified information. Because federal government. So the federal government has a right to know what you're doing. Okie dokie. The petitioners over here, a birth mother, a foster parent, and adoptive parents, and the state of Texas, filed this suit in federal court against the United States. Several Indian tribes intervened to defend the law alongside the federal parties. The petitioners challenged the law as unconstitutional on multiple grounds. Okay. They assert that Congress lacks the authority to enact the law, and several of the law's requirements violate anti-commandeering principle of the 10th Amendment. Yeah, not so sure about that one, to be honest. Okay, so let's go over the basics. Anti-commandeering principle is a principle that's well understood that basically says the federal government, as a general rule, cannot force states to do their bidding. The federal government can't make state governments do stuff. They cannot take over state-level apparatuses. If the federal government wants to enforce their laws, cool. Hire your own police. Get your own courts. But don't talk to the states about it. You can't make the states enforce federal law. But is that true in this specific context? Because while there is a specific constitutional authority which gives the federal government the ability to regulate relationships with the tribe, so maybe that anti-commandeering principle needs to take a back seat. It's at least debatable, right? So it's like, okay, I'm not sure if the anti-commandeering applies in this context or not. But that's what they're talking about. Can the federal government make the state do stuff? All right. They argue the act employs racial classifications that unlawfully hinder non-Indian families from fostering or adopting Indian children. Yeah, but the Constitution, though. So I'm not sure that's a problem, but all right. And they challenge the relevant law, the provision that allows tribes to alter the prioritization order on the grounds it violates non-delegation, because we're giving it to the tribes themselves. But the tribes do have this status as domestic countries. So maybe that's a little bit different. Maybe they are a government because they're domestic countries. They're dependent domestic countries, I believe is the exact language in the federal statutes, if memory serves correctly. I think it's dependent domestic nations, I think is the exact language the federal government uses. What does that mean? But yeah, maybe because normally we can't give legislative authority to a private entity. That's the problem, right? Congress can't empower the Kennel Club to start passing regulations on dogs because it's a private entity. But the tribes are the tribes a private entity, but they're a dependent domestic nation. So maybe that's different. And maybe we just empowered the state government that is the tribes. Indian law gets complicated. Let's press on. The district court granted petition's motion for summary judgment on the constitutional claims, and the en banc Fifth Circuit affirmed in part and reversed in part. The Fifth Circuit concludes the act does not exceed Congress's legislative power, the relevant section does not violate non-delegation, and some of the law's placements satisfy the guarantee of equal protection. Yeah, the Fifth Circuit was evenly divided as to whether the other preferences, prioritizing other families and Indian foster homes over non-families, unconstitutionally discriminates on the basis of race. Even if it is discrimination on the basis of race because of direct constitutional authority, it might be legal anyway. Maybe the discrimination on the basis of race is totally fine because the Constitution does talk about the federal government's ability to, deal with the relationships with the Indian tribes. So is it racism? Maybe. Is it legal? Quite possibly. Let's press on. As the petitioner's 10th Amendment arguments, the Fifth Circuit held that the active efforts requirement and the expert witness requirements and record-keeping requirements unconstitutionally commandeer the states. Questionable. Tribes, that anti-commandeering principle is important and all, but these are dependent domestic nations. And so, maybe that's different. This is constitutional nightmare fuel because of all this stuff. This is how we have fun in Constitution land. Okay. And because it divided with respect to these other challenge provisions, notice requirements and placement preferences and record keeping, the Fifth Circuit affirmed. No problem. The Supreme Court's here to come to the rescue and help clarify all these wonderful constitutional nightmare fuel. So let's figure out what the law is. That's great. All right, let's press on. All right, the court declines to disturb the Fifth Circuit's conclusion. The act is consistent with the Article 1 authority. So the act is constitutional. Okay. The court has characterized Congress's power to legislate with respect to Indian tribes as plenary and exclusive, superseding both tribal and state authority. Yeah, that much is true. The United States government's authority over the tribes is absolute. So, yeah, okay, fine. The court has traced that power to multiple sources. First, the Indian Commerce Clause authorizes Congress to regulate commerce with the Indian tribes. And the court has interpreted the Indian Commerce Clause to reach not only trade, but also Indian affairs. The Treaty Clause provides a second source of power. The treaty power does not literally authorize Congress to act legislatively, since it's housed in Article 2, but treats treaties made pursuant to that power that can authorize Congress to deal with matters which otherwise Congress could not deal. Also, principles inherent in the constitutional structure may empower Congress to act in the field of Indian affairs. Finally, the trust relationship between the United States and Indian people informs the exercise of the legislative power. In sum, Congress's power to legislate with respect to Indians is well established and broad, but is not unbounded. It's plenary within its sphere, but even a sizable sphere has borders. Ooh, exciting. So it's absolute within the boundaries, but then we get to play with the boundaries. Fun. Petitioners contend that the act impermissibly treads on states' traditional authority over family law, but when Congress validly legislates pursuant to Article 1, the court has not hesitated to find conflicting state law preempted, notwithstanding the limited application of federal law in the field of domestic relations generally. Yeah, the federal government doesn't have a lot of authority when it comes to family law, but the tribes, though. So, yeah. And the court has recognized Congress's power to displace the jurisdiction of state courts in adoption proceedings involving Indian children. Sounds about right. Yeah. Petitioners contend that no source of congressional authority authorizes Congress to regulate custody proceedings for Indian children. They suggest that the Indian Commerce Clause, for example, authorizes Congress to legislate only with respect to Indian tribes as governmental entities, not Indians as individuals. Fair. But this court holding more than a century ago that commerce with the Indian tribes means commerce with individuals composing those tribes renders that argument a dead end. Dude, is that really what they meant? Literally? Okay. I mean, I guess I could go reread that case. But like, did they literally mean that the Indian Commerce Clause really speaks to each particular individual? Did they mean that literally? In that case, I have questions about that one. I have my doubts they meant that literally, Supreme Court. I mean, you're quoting yourselves, but I'm not sure you're quoting yourselves faithfully on that one. Yeah. Petitioners also assert that the act takes commerce out of the Indian Commerce Clause because children are not commodities that can be traded. Yeah, I mean, looking at adoption proceedings as commerce is one strange way of looking at commerce. This point, while rhetorically powerful, ignores the court precedent interpreting the Indian Commerce Clause, not only with respect to trade, but other Indian affairs. Children are commerce now. Children are commerce. Okay. Children are commerce. I guess that federal law can authorize the children to be bought and sold on a market now. Exciting. It means the federal government can take them and sell them at some sort of market. That doesn't raise any sort of dark utopian nightmare problems. No sirree. Okie dokie, children are commerce. Let's not think about that too hard. Petitioners next argue the act cannot be authorized by a principle inherent in the Constitution structures because those principles extend at most to matters of war and peace. Again, petitioners make no argument this takes the court cases on their own term. The court has referred generally to powers necessarily inherent in any federal government and has offered non-military examples such as creating departments of Indian affairs. Petitioners next observe that the act does not implement a federal treaty, but Congress did not purport to act pursuant to a treaty, and the Fifth Circuit did not uphold it pursuant to that rationale. Finally, petitioners turn to criticizing the court precedent as inconsistent with the Constitution's original meaning, but they neither ask the court to overrule the precedent they criticize, nor try to reconcile their approach with it. If there are arguments that the act exceeds congressional authority, as precedent stands today, petitioners do not make them. Really? Really? Petitioners didn't challenge the constitutionality of, didn't challenge the precedent? Seriously? This seems like you're trying to be real cute, Supreme Court. This is like, well, they never technically asked us, so we don't have to answer the question. This seems like you're being very, very cute right now. I don't know about that one either. Petitioners' anti-commandeering challenges, which address three categories of the act, are rejected. First, petitioners challenge certain requirements that apply in the involuntary proceedings to place a child in foster care or terminate parental rights, focusing on the requirement that the initiating party demonstrate active efforts to keep the family together. Petitioners contend this subsection directs state and local agencies to provide extensive services to the parents of the children, even though it's well established the 10th Amendment bars Congress from commandeering the states or those political subdivisions to administer or enforce a federal regulatory program. Well, that is typically true. Is it true here? To succeed, petitioners must show that the act harnesses a state legislative or executive authority. But the provision applies to any party who institutes proceedings, thus sweeping in private individuals and agencies, as well as governmental agencies. A demand that either public or private actors can satisfy is unlikely to require the use of sovereign power. Okay. Petitioners nonetheless insist that states institute the vast majority of the involuntary proceedings, but examples of private suits are not hard to find. Well, that kind of defeats the point. Yeah, I mean, most of the time, it's the state that's trying to take the children away from parents in an involuntary manner. Yes, private parties can do this. Yes, you can find examples, but that doesn't really undermine the point that the state is usually the one doing this. But okay, let's pretend it does. Examples of private suits are not hard to find. And while petitioners treat active efforts as synonymous with government programs, state courts have applied the active efforts requirement in private suits too. That's consistent with the Act's findings, which describe the role that both public and private actors played in unjust separation of children from their families. Given all this, it's implausible the Act is directed primarily, much less exclusively, at the states. Legislation that applies even-handedly to states and private actors does not typically implicate the 10th Amendment. Petitioners would distinguish the court's precedent, so holding on the grounds those cases address laws regulating a state's commercial activity, while the Act regulates core sovereign function of health and safety for children. This argument is presumably directed at situations in which only the state can rescue a child from neglectful parents. But the state is not necessarily the only option for rescue, and the Act applies to other types of proceedings too. Petitioners do not distinguish between these varied situations, much less isolate a domain in which only the state can act. If there is a core of involuntary proceedings committed exclusively to the sovereign, Texas neither identifies its current contours nor explains what the Act requires of the states in that particular context. Again, it feels like we're trying to be too clever. It feels very much like we're really desperately trying to avoid the issue. We're grasping at straws a little bit, it feels like, Supreme Court. I have to be honest. And the petitioner's challenge for other provisions of the Act, the notice requirement, expert witness requirement, and evidentiary standards, the court downs to the requirements placed on the state as litigant implicate the 10th Amendment. But regardless, those provisions likely apply to both private and state actors, and so pose no anti-commandeering principles. Okay. Sure. Why not? How are we doing over there in chat, by the way? I see I lost most of the people watching the chat. I guess some people are not interested in U.S. Supreme Court. How are we doing over there in chat? We following along? Even though it's kind of a little nebulous. Okay. All right. Yeah. All right. Okay. Petitioners next challenge the Act's placement preferences. Petitioners assert that the provision orders state agencies to perform a diligent search for placements that satisfy the Act's hierarchy. Just as Congress cannot compel state officials to search databases to determine the lawfulness of gun sales, Congress cannot compel state officials to search for a federally preferred page placement. We're comparing Indian children to firearms? That seems like okay. As with the Act, they have not shown the diligent search requirement, which applies to both public and private parties, demands the use of state sovereign authority. Moreover, the Act does not require anyone, much less the state, to search for alternative placements. Instead, the burden is on the tribe or other objecting party to produce the higher ranking placement. So as it stands, petitioners assert an anti-commandeering challenge to a provision that does commandeer the state agencies to do anything. Okay. States' courts are a different matter. The Act indisputably requires them to apply placement preferences in making custody determinations, but Congress can require state courts, unlike state executive and legislative, to enforce federal law. Fair enough. I mean, that is a point of distinguishment, so sure. Petitioners draw a distinction between requiring state courts to entertain federal causes of action and requiring them to apply federal law to state causes of action, but the argument runs counter to the Supremacy Clause. When Congress enacts a valid statute, state law is naturally preempted to the extent of the conflict. That a federal law modifies state law cause of action does not limit the preemptive effect. Okay. Finally, petitioners insist that Congress cannot force state courts to maintain or transmit records of custody proceedings involving children. But the anti-commandeering doctrine applies distinctively to state courts' adjudicative responsibilities. The Constitution allows Congress to require state judges to enforce federal prescriptions insofar as those prescriptions relate to matters appropriate for judicial power. In Prince, the court indicated the principle may extend to tasks that are ancillary to quintessentially adjudicative tasks, such as recording, registering, and certifying documents. Prince describes numerous historical examples of Congress imposing record-keeping and reporting requirements on state courts. These earlier congressional enactments demonstrate the Constitution does not prohibit the federal government from imposing adjudicative tasks on state courts. The court now confirms what Prince suggested. Congress may impose ancillary record-keeping requirements relating to state court proceedings without violating the 10th Amendment. Well, as it extends to courts, I guess that's fine. So fine. Here, the Act's record-keeping requirements are comparable with a historical example. The duties imposed are ancillary to the obligations to conduct the proceedings in accordance with the Act. The court does not reach the merits of petitioners' two additional claims, the equal protection challenge to the Act's preferences and the non-delegation challenge, the provision allowing tribes to alter placement, because no party before the court has standing to raise them. Okay. So we're not going to raise equal protection or non-delegation because no one has standing? Okay. The individual petitioners argue the Act's hierarchy of preferences injures them by placing them on unequal footing with Indian parents who seek to adopt or foster children. But the individual petitioners not shown this injury is likely to be redressable by judicial relief. They seek an injunction preventing the federal parties from enforcing the Act, and declaratory judgment the Act challenged the provisions are unconstitutional. Yet enjoining the federal parties would not remedy the alleged injury because state courts apply the placement preferences and state agencies carry out the court order placements. The state officials who implement the Act are not parties to the suit, and there's no reason they should be obliged to honor the incidental legal determination suit produced. Petitioners' request declaratory judgment suffers from the same flaw. The individual petitioners insist that state courts are likely to defer to federal courts' interpretation of federal law, thus giving rise to substantial likelihood that judgment will redress their injury. But such a theory would mean redressability be satisfied whenever a decision might persuade actors who are not before the court. It's the federal court's judgment, not its opinion, that remedies the injury. The individual petitioners can hope for nothing more than opinion, so they can't satisfy Article 3. Oof. Dude, we're dancing on the heads of pins over here big time. We're dancing on the heads of pin big time. Woof. How does no one have standing? Well, we haven't gone to the equal protection part yet. Texas has no equal protection rights of its own and cannot assert equal protection claim on behalf of its citizens. The state's creative arguments for why it has standing despite these rules fails. Texas arguments that the Act requires it to break its promise to its citizens. They'll be colorblind in custody proceedings is not the kind of concrete, particularized invasion of protectable interest necessary to demonstrate injury in fact. Texas also claims a direct pocketbook injury associated with costs of keeping records, providing notice, and producing expert testimony before moving a child. But these alleged costs are not fairly traceable to the placement preferences, which operate independently of the provisions. Texas would continue to incur the costs even if we were relieved of the duty to apply the preferences. Because Texas is not injured by the preferences, neither would be injured by the tribal resolution that altered those preferences. Texas does therefore have standing to bring its equal protection. Okay. And although the individual petitioners joined Texas non-delegation challenge, they raised no independent arguments about why they'd have standing. What? Why don't they have standing? What? Barrett delivers an opinion in which Robert, Sotomayor, Kagan, Gorsuch, Kavanaugh, and Jackson join. Thomas and Alito dissent. How do they not have standing? How does that work? Hold on. Hold on. Alt F. Find. Let's see. Wait. The individual petitioners argue the Act injures them by placing them on unequal footing, but the individual petitioners not shown this injury is likely to be redressable. They seek an injunction from the federal parties. The state officials who implement it are not parties. Petitioner's request for declaratory judgment suffers from the same flaw. Uh-huh. 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 Okay. Okay. Uh-huh. 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 So we say we sued the wrong people? Okay. Thus, that brings us to the end of this discussion about the Indian Child Welfare Act and its relation on adoptions in the United States. Long story short, tribes are different, is basically what this fundamentally boils down to. The commandeering principle doesn't really apply because we're only ordering courts to do things, and we can do that because they're required to uphold the law. And the private parties can also do the required showing of the steps they took to help with the family. So this isn't a burden on the states. But to be honest, it feels a little bit like we're going a little bit out of our way in some of these parts. So it feels a little like we're dancing on the head of a pin. And I'm not 100% sure the Supreme Court is quoting its own precedent right on some of this stuff. So, yeah. But I think it's basically because tribes, though, they find that the Congress has the plenary power with respect to tribes, and this is part of the tribes. So it's all good. And the commandeering principle doesn't apply because it's an order to states, and the record keeping arguments don't apply because it's ancillary as part of the judicial role. And so keep doing that in a 7-2 decision. So interesting, a little bit questionable in parts, a little bit dancing on the head of a pin. But that for the moment brings us to the end of discussion of this case. Yeah, it's okay, that's a lot. Yeah, that's a lot. Ugh. Let's move on to the next Supreme Court case. Yeah, 100% because tribes. That's basically what it boils down to. Because tribes, that's what it boils down to. That's what it boils down to. All right, let's read the next opinion. How am I doing on time? I got a half hour to go through 2 cases. Oh, great. Can I do 2 Supreme Court cases in a half hour? Let's find out. Push the button. Thank you. Yeah. For today's story, we deal with the bankruptcy code as it relates to Native American tribes. Congress has the ability to regulate the tribes. The tribes are best understood, according to the federal government, as dependent domestic nations. And so they have a sovereign immunity. But the sovereign immunity can be waived by the federal government, but it has to do so in a clear, unmistakable way. So the relevant question is, when Congress passed the bankruptcy code, did they abrogate the sovereign immunity of the tribes with respect to bankruptcy issues, or are tribes subject to different bankruptcy rules than other people? Let's get started with this. The petitioner, La du Flambeau Band of Lake Superior Chippewa Indians, is a federally recognized Indian tribes. One of the band's businesses, Len Green, extended a respondent a payday loan. Oh yeah, I remember these. These used to be big commercials. I don't know if they still do this, but I remember seeing some of these commercials. Yeah, we'll give you a payday loan. And then they would jack up the interest to crazy amounts because they aren't subject to the usual usury requirements, because they aren't subject to state law. So there were some tribes doing some very questionable lending at some very high interest rates. Shortly after receiving the loan, the defendant over here filed for a bankruptcy protection, which triggered an automatic stay under the bankruptcy law against further collection efforts. The tribe, through its institution, attempted to continue collecting the debt. He filed a motion in bankruptcy court to enforce the automatic stay and recover damages. The bankruptcy court dismissed the suit on tribal sovereign immunity grounds. The First Circuit reversed, concluding the code unequivocally strips the tribe. So yes, when you file bankruptcy, it automatically stays all proceedings. The tribe tried to collect anyway. And then when they went to bankruptcy court, it's like, well, the stay doesn't apply because they're tribes. So does it apply or not? Hell, the bankruptcy code unambiguously abrogates the sovereign immunity of all governments, including the Indian tribes. Two provisions of the bankruptcy code lie at the heart of the case. The first expressly abrogates the sovereign immunity of governmental units for the enumerated purpose. The second defines governmental units as United States, state, commonwealth, district, territory, municipality, foreign state, department, agency, or other instrumentality of the United States, a state, a commonwealth, district, territory, municipality, or a foreign state, or other foreign or domestic government. And that would seem to qualify as to tribes. In order for the provisions to abrogate sovereign immunity, Congress must have made its intent unmistakably clear in the language of the statute. If a statute can plausibly be read to preserve sovereign immunity, Congress has not expressed it unambiguously. But Congress need not use any particular words. So it has to do so unambiguously, but doesn't need to use particular words like the Indian tribe's sovereignty is revoked. Okay, fine. The bankruptcy code unequivocally abrogates the sovereign immunity of any and every government with respect to assert such immunity. Because federal tribes unquestionably fit the description, the code's abrogation plainly applies to them as well. Several features of the statute's text and structure point this way. To start with, the definition of governmental unit exudes comprehensiveness. It begins with a long list of governments varying in location, size, and nature, then proceeds to capture subdivision and components of every government, and concludes with broad catch-all phrases, sweeping in other foreign or domestic governments. Moreover, the catch-all phrase pairing of the extremes, foreign or domestic, appearing at the end of the extensive list, unambiguously identifies Congress's intent to cover all governments by the definition. The abrogation provision, in turn, applies to every governmental unit. It does not cherry-pick governments from the capacious list. Other provisions of the bankruptcy code reinforce the statute's text. To facilitate orderly and centralized debt, the code includes a number of requirements like automatic stays that generally apply to all creditors. The basic requirements can be enforced against all kinds of creditors, whether the creditor is a governmental unit or not. At the same time, the code contains limited exceptions to avoid impeding the functions of governmental entities when they act as creditors. Reading the statute to carve out certain governments from the definition of governmental unit, as petitioners would do, risks upending the policy choices the code embodies. And there's no indication that Congress meant to categorically exclude certain governments from their protection mechanisms. Federally recognized tribes are indisputably governments. They exercise unique governmental functions, and both Congress and this court have repeatedly characterized them as governments. Accordingly, because the bankruptcy code unambiguously abrogates the sovereign immunity of all governments, and tribes undoubtedly count as governments, the code unmistakably abrogates tribal sovereign immunity. Petitioners fail to show doubt into these clear statutory provisions. Petitioners insist that neither act mentions tribes by name, but Congress need not use any particular words to make its intention clear. And the fact that Congress referenced tribes specifically in other statutes abrogating tribal immunity does not foreclose it from using different language to accomplish the same goal in other statutes. So in other contexts, they've actually used the word tribes or named tribes. Here they didn't do that, but they referred to all domestic nations, so that would seem to qualify. Petitioners also contend the catch-all phrase other foreign or domestic government can plausibly be read to include other entities that are only purely foreign or purely domestic. In petitioners' view, the catch-all phrase would thus exclude tribes or other governments that have foreign and domestic features. But Congress has expressly instructed the word or as used in the code is not exclusive. In any event, petitioners do not explain why the bankruptcy code would draw such a line in the sand. Finally, petitioners suggest that Congress has historically treated various types of governmental entities different for the purpose of bankruptcy law, relying on provisions predating the bankruptcy code's enactment. Yet petitioners failed to demonstrate the code, which comprehensively revised the practice, carried forward any such differential treatment. Justice Jackson delivers the opinion of the court, in which Justice Gorsuch files a dissent, an 8-1 opinion. And me being a Justice Gorsuch fanboy, I'm a little bit interested in the dissent, but that will have to wait for another time. Thus, that brings us to the end of the case dealing with the Bankruptcy Code. And the U.S. Supreme Court rules the Bankruptcy Code is one size fits all, applies to everyone, state, foreign, municipality, cities, counties, and also the Indian tribes, and looks at the overall comprehensive list. It might not use the word Indian tribes, but it does refer to domestic nations or domestic entities, of which tribes are one. So the Supreme Court rules that the tribes are also subject to the Bankruptcy Code, so he can get his bankruptcy protection as a creditor. And that, for the moment, brings us end of discussion of this case. Push the button. Push the button. Yeah. All right, what else we got for me? Okay. Can we retry a defendant when they were tried in the wrong place? Okay, let's find out. How long do I have? 15 minutes? No problem. Excuse me. Excuse me. Or for today, no. For today's case, we discuss when a person can be retried for the same crime. In this case, a person was tried, but tried in the wrong place, the wrong venue. Can we retry them in the correct venue, or does that pose a double jeopardy problem? Let's get started with this. Timothy Smith was indicted in the Northern District of Florida for theft of trade secrets from a website owned by the company Strikelines. Before trial, Smith moved to dismiss the indictment for lack of venue, signed the Constitution's venue clause and its vicinage clause. Smith argued the trial in the Northern District of Florida was improper because he'd accessed Strikeline's website from his home in Mobile, which is in the Southern District of Alabama, and the servers storing the data were located in Orlando, which is in the Middle District of Florida. The district court concluded that factual disputes relating to venue should be resolved by the jury and denied the motion to dismiss without prejudice. The jury found that Smith guilty, and Smith moved for a judgment of acquittal based on improper venue. The district court denied the motion, reasoning that the effects of the crime were felt as Strikeline's headquarters, which were located in the Northern District of Florida. On appeal, the 11th Circuit determined that venue was improper, but disagreed with Smith that the trial in the improper venue barred re-prosecution. The 11th Circuit therefore vacated the conviction for theft of trade secrets. Okay, so can we retry the guy in the right place? The Constitution permits the retrial of a defendant following a trial in an improper venue conducted before a jury drawn from the wrong district. Except as prohibited by the double jeopardy clause, it has long been the rule that when a defendant obtains reversal of prior unsatisfied convictions, he may be retried in the normal course of events. So yes, if your conviction is reversed, for example, because of evidentiary problems, like they didn't give you the evidence, then typically you can be retried. We'll give you the evidence and you get another go. All right, in all circumstances outside the speedy trial clause, the strongest appropriate remedy for trial error is a new trial, not a judgment that bars re-prosecution. Text and precedent provide no basis for concluding that violations of venue and vicissitudes clause are exceptions to the retrial rule. The venue clause mandates that trials of all crimes shall be held in the state where the crimes have been committed. Nothing about the language suggests a new trial in a proper venue is not an adequate remedy for the violation. Smith argues primarily that the venue clause aims to prevent the infliction of additional harm on a defendant who's already been undergoing the harm of the initial trial in a distant, improper place. I mean, there are a lot of expenses and also your time and energy and a lot of other things. So there is some harm from being put on trial. But mere burden of a second trial has never justified an exemption from the retrial rule. Too bad, so sad. Indeed, while the most convenient trial venue for a defendant would presumably be where he lives, the venue clause is keyed on the location of the alleged crime. The clause does not allow variation for the convenience of the accused, and this court has repeatedly rejected objections based on hardships created when the defendant is prosecuted far from home. The vicinage clause, which guarantees the right to an impartial jury of the state and district where the crime shall have been committed, similarly provides no support for Smith's argument that retrial is barred. The vicinage clause differs from the venue clause in two ways. It concerns jury composition, not the place where the trial can be held, and it constitutes the district where the crime was committed rather than the state. Nothing about these differences dictates a remedy that's broader than the one awarded when the venue clause is violated. The vicinage clause is only one aspect of the jury rights provided by the Sixth Amendment, and this court has repeatedly acknowledged that retrials are appropriate remedies for violations of other jury trial rights. Most analogous to this case, the court has held retrial is an appropriate remedy when the defendant is tried by a jury that does not reflect a fair cross-section of the jury. So, for example, if they're biased, or for example, the prosecutor kept out all the people of a particular race or all the people of a particular sex, among other things. So if the jury is not a fair composition, then get a new jury and let's try again. There's no reason to conclude that trial before a jury drawn from the wrong geographic area demands a different remedy. The historical background of the venue and vicinage clauses similarly does not demand a departure from the rule. The common law vicinage right presumptively entitles defendants to a jury of a neighborhood where the crime was allegedly committed. As a practical matter, this right imposed a venue requirement. Trials need to be held at a location, the matter of fact issuable allegedly to occur to the allowed to the inhabitants whereof to serve on a jury. History reveals that common law vicinage's rights were highly prized by the founding fathers, and this right undoubtedly inspires the venue and vicinage's clauses in the Constitution. Although the clauses as adopted depart in some respects from the common law, most notably by providing new specifications about the place where a crime may be tried, there's no meaningful effort to support the contention the Constitution altered the remedy prescribed by common law for violations of the right. So although it does modify the common law slightly, the remedy is the same remedy the common law recognizes, merely a do-over. By the time of the founding, compelling evidence supported the conclusion that pleas of prior acquittal or conviction could not be grounded on a verdict issued in or returned by a jury of a wrong vicinage. Judicial decisions and prominent treatises of the time and since reflect no common law principle at the founding that preclude retrial found in a trial found in improper venue or before improper jury. Indeed, this court embraced this retrial rule for venue error, and this decision did not break new ground. This strongly implies that even if you're found not guilty, they can retry you if they found that they tried you in the wrong place. The court has found that Smith points to no decision barring retrial based on successful venue or vicinage objection, either centuries of common law predating the founding or earlier years of practice following ratification. The absence alone is considerable evidence the clauses do not bar retrial in their own forces. Moreover, courts affirmatively allow retrial following trials in improper venue or before improperly constituted juries. This leaves no reason to doubt the retrial rule appeals here. The court rejects Smith's argument that double jeopardy clause is implicated by retrial in a proper venue. A judicial decision on venue is fundamentally different from a jury's general verdict of acquittal. When a jury returns a general verdict of not guilty, its decisions cannot be upset by speculation of such matters by courts. I'd like to take note here that the Supreme Court just used the phrase jury's general verdict of acquittal. So, just pointing that out. And because it's impossible for the courts to be certain about grounds for the verdict without impermissibly delving into jury deliberations, the basis for the jury verdict cannot be ground for setting aside the acquittal. Generally, verdicts of acquittal are thus consistent with the rule that culpability is the touchstone for determining whether retrial is permitted. Under that rule, when a trial terminates with the finding the defendant's criminal culpability has not been established, retrial is prohibited. Conversely, retrial is prohibited when a trial terminates on the basis unrelated to factual guilt or innocence of which the offense is accused. For example, a jury deadlock. So trial can be done in those circumstances. Similarly, reversal of conviction based on violation of venue or vicinage's clause, even when styled as judgment of acquittal, plainly does not resolve the bottom line question of criminal culpability. In this case, the 11th Circuit's decision venue was improper, did not adjudicate Smith's culpability, and thus does not trigger the double jeopardy clause, Alito delivering the opinion for a unanimous Supreme Court. Thus, that brings us to the end of this case, dealing with whether or not you can be retried twice. In this case, this person was found guilty, but by a court in the wrong place. And much like other injuries where a person is found guilty, retrial is permissible. So we can retry the defendant. The same as if we had, not given you the evidence. We committed a Brady violation. No problem. Here's the evidence. Let's try again. We did a bad on the jury. No problem. Let's try again. There is some language here that sort of implies that even if you're found not guilty, that they can retry you. The Supreme Court tries to take that back in the back half, but I imagine someone somewhere is going to try this at some time. Oh, we tried you in the wrong place. You're found not guilty and all, but it's the wrong venue. And the Supreme Court said that we can retry you. There's language that allows for that. So the Supreme Court themselves opened up a problem for the future someday. But that's where we are right now. So we'll deal with that problem another time. And that, for the moment, brings us to the end of discussion of that story. Okay, great. So we're finally done. How are we doing on the tweets and retweets thing? Only 42. Well, maybe we can get 50 retweets in the afternoon session because we didn't quite make our goal. But I do appreciate the 42 of you who retweeted. So yes, so all that stuff. So I have 7 minutes before the case restarts, which is probably not enough time to get my steak ready. But I will stop the stream and at least get myself a water and stretch and start my drying. And then I will start the trial and then probably make lunch after the case starts. So we'll get you going, and then I'll put myself off camera because I don't have enough time to make lunch. So all the rest of it. And yes, I'm going to have another T-bone, and I'm very, very excited about it as well. So all that good stuff. All right. So I'm going to sign off for now. I will see you in 7 minutes. You should be automatically redirected over there. And until later, my friends, I hope all's well. Cheers, my friends, and goodbye.